cell phone off, please. Please rise. The justices of the Appellate Division Supreme Court First Department. He or person having business with the Appellate Division. So here, in attendance and shall be heard. Please be seated. Good afternoon, lawyers. Okay, you've heard this before. We have over 5 hours of oral arguments. We're quite familiar with your cases. Please ask for the time that you need, not the time that you want. I will begin with a call of the calendar. People versus Curley. I couldn't hear that. 6 and 2? Okay, so I'll do 5 and 2 and 5. G. Children is submitted. People versus John Arce. That's submitted. Carlin versus William Gottlieb Management. Appellate. 6 and 2. Can you please keep your voices up so that I can hear you? Respondent Carlin. So I'll do 5 and 2 and 5. Okay, Kirby versus Carlos Bakery. 5 for Appellant Kirby, 5. 1 in rebuttal. Carlos Bakery responding. 5 for responding, Your Honor. 5 and 1 and 5. Lawler versus WYMBS Inc. Let me hear from appellant WYMBS, and this case is going to be called first, so be aware of that. Appellant? Appellant judge, 10 minutes and 5 minutes. Thank you. Okay, I'll take 6 minutes. Okay, so I'll give you 6 and 2 and 6. Remember, the clock is for you, not for us. If we have questions, we're going to go until we get done. Lefkowitz versus Terrence Cardinal Cook. For appellant, I'll go with the 5 and 1. Appellant Lefkowitz, 5 and 1. Terrence Cardinal Cook responding. 5. 5 and 1 and 5. People versus Pedro Torres. For Mr. Torres, 4 and 1. People? The people request 4. 4 and 1 and 4. WP Children is submitted. Smartmatic USA versus Fox Corporation et al. 10 and 3. Tell me who you are. Stephen Mintz, Vincent Gold, with me, Paul Clement, by Commissioner Okay, we have appellant and cross appellant, so let me get appellant Smartmatic first.
Your Honor, good afternoon. Edward Whipper from Bench for the Smartmatic respondent appellants. We request the same amount of time last time.
How much is that?
We were going to request 12 and 3, we'll take 10 and 3.
Okay.
And Mr. Connolly brought up each area to be argued.
So tit for tat. Tell me how much time you want?
10 and 3, Your Honor.
Okay, so 10 and 3, and that's for Fox.
For Fox.
Okay. The other, that's it. Okay, so 10 and 3. And then Smartmatic, I'll give you 10 and 3. People versus Duncan. Submit it. Okay. Elder versus Nightshade, submitted. Basden versus Liberty Lines.
Your Honor, good afternoon. Michael Betzberg on behalf of the appellant. I'll request 8 and 2, please.
Your Honor, Carol, looking for respondent on request 7.
Okay, so 8 and 2 and 7. Juray versus Ulukaya.
Appellant 7 and 2, Your Honor.
Respondent Ulukaya.
For the respondent 7, please.
Okay. People versus Pimentel.
Appellant 4 and 2, Your Honor.
4 and 2. People. Do you wish to submit?
No, I'd like to still argue, Your Honor.
Okay, so I'll give you 3 minutes. And submit it for the people. People versus Bonnet. Appellant Bonnet.
I'll submit for the people.
Okay. So submit it. Okay, and now you have 2 non-enumerated that I granted time to. Gibson Dunn. I will give you 4 and 1. And respondent Donna, I'll give you 4.
Thank you, Judge.
And Sinchheimer, appellant Sinchheimer, I gave you 3 and 1. And Park and 66 Corp, I'll give you 3.
Thank you, Your Honor.
I'm a glutton for punishment. People versus Curley is the first case. No, I'm so sorry. Lawler versus WYMBS is the first case to be argued. Go ahead.
Good afternoon. My name is Deanna Panico. I'm from the law firm Be Ready Fishbein, Hatter and Donovan, and we represent the appellant/defendant, WIMS, Inc., in this action. May it please the court. It is black-letter law that in order for an employee to sustain a cause of action for a whistleblower retaliation claim against his employer, the employee must be able to prove that the employer engaged in a practice that was an actual violation of law. In other words,
Counsel, this is a pleading motion, correct?
I'm sorry?
It's a pleading motion, right?
Yes, that's correct.
And so why isn't Weber enough to get plaintiff over that threshold?
Because in Weber, there was the underlying decision by the Supreme Court relied on Weber, but it was an erroneous interpretation of that law. In Weber, the judge did not say that the plaintiff does not have to plead an actual violation of law. It was actually to the contrary. In Weber, there was an employee who alleged violations by their employer which it was a healthcare facility, and the employee had alleged that there were fire code violations. That
So
there-
Webb Weber says that for pleading purposes, the complaint need not specify the actual law, rule, or regulation violated. Rather, the complaint must identify the particular activities, policies, or practices in which the employer allegedly engaged so that the complaint provides the employer with notice of the alleged complaint of conduct. Here, we are talking about COVID-related regulations, specifically the executive order signed by the by the governor, stating that you must mask and you also you must
Socially
mask
distant.
up, and you also there must be social distance, or you must socially distance. The allegation in the complaint is that the employer did not abide by this regulation in that he allowed his son to come to the workplace without a mask on numerous occasions, and also that the son did not engage in social distance.
That's correct, Your Honor. The Webb case did hold that the plaintiff does not need to identify the specific statute that was violated, and I'm not disputing that. But what Webb Weber had held was that the allegations, the underlying allegations, the substantive allegations, and again, that was reaffirmed by the HC2 case, the substantive allegations of the complaint do in fact need to make out a violation of law by the employer. It is not
But it
enough-
doesn't say that. I mean, for pleading purposes, the complaint need not specify the actual law, rule, or regulation violated.
Correct.
Unquote.
Correct, Your Honor, but if you keep reading on, it then says that the substantive allegations of the complaint that was
Rather,
made by
well,
Weber.
I'll keep going. Rather, the complaint must identify the particular activities, policies, or practices in which the employer allegedly engaged, so that the complaint provides the employer, and that was read to you before, with notice. All you need is notice of what is, remember, this is a pleading stage.
Yes, Your Honor, but again, the court in Weber goes on to hold that the substantive allegations of the complaint need to make out an actual violation of law. And Your Honor, I could step back even further, pointing to, the judge had pointed out the executive orders that the plaintiff in this case alleges that WIMS had violated. None of those executive orders were actual, the factual allegations in the complaint don't make out an actual violation of any of those executive orders. So for example, the plaintiff
Well,
points to Executive Order 202.8. Executive Order 202.8 does not even contain the word face masks or social distancing in it. Executive Order 202.17 refers to an individual. An individual that was over the age of 2 was required to wear a mask. However,
Right.
there was no...
And that did not include the owner's son, who just kept coming in without a mask?
But that is not a
without
violation of law by the defendant. That would be
So
potentially a
again, you're
violation
going
of law.
back to your reading of Webb Weber that says that, I guess you read it differently. You don't think, there has to be an alleged violation of law rather than executive order. I mean, we'll ignore the fact that the legislature basically abdicated all its responsibilities to the governor during a pandemic, during a health emergency.
Your Honor, I respectfully disagree with that. The executive orders were issued pursuant to an authorization from the state legislator that authorized the governor to suspend laws. It didn't give the governor the authority to enact laws. But Your Honor,
But they later on passed the law, right?
that it's getting away.
Outlining precisely the requirements of the executive orders. They
Your
could
Honor-
have done that during the pandemic, and they didn't, right?
But Your Honor, we're talking about a time during the pandemic. We're talking about executive orders that the plaintiff is pointing to in his complaint, that the factual allegations in the complaint do not create an actual violation of law by the employer. And frankly, Your Honor, what the plaintiff is really looking to rely on is 10 NYCRR 66-3.2. And that was an actual regulation that was enacted that said that in the event that an individual shows up at a place of business and is not masked, then in that instance, the employer has an obligation to kick that individual out of his place of business. That particular regulation was not enacted until after the plaintiff's employment ended. And so that particular regulation cannot form the basis of a whistleblower claim, of the plaintiff's whistleblower claim.
Thank you, counsel.
Thank you, Judge.
Good afternoon. May it please the court, Stephen Bergstein for the plaintiff. We have a threshold issue here that the parties have briefed, which is the basis for the legislative basis for the executive order. Under Section 740, 1C, any rule or regulation promulgated under state law, the executive.
But that was not law until 2021, right?
But it was a rule/regulation. Any rule regulation violation that's promulgated under state law, that's the executive order, was promulgated under the state legislature, giving the governor emergency authority to do whatever it takes to slow down the COVID pandemic. So that is the executive order. That's the 10-point pause plan.
But more fundamentally, don't the governor's power ultimately derives from a statute to issue these executive orders, right?
Correct.
Executive Law 29-A.
And the state legislature passed a statute stating the governor basically do what you have to do to mitigate this serious public health emergency. And the executive orders were issued pursuant to that. And the labor law 740 recognizes that certain rules that are not statutes can predicate a whistleblower retaliation claim, and that's what we have here.
But counsel, should we draw a negative inference from the fact that 740 was amended after the incidents that took place that give rise to this lawsuit, and that the amendments explicitly said that executive orders would be included?
That's what it says, but even prior to that amendment, the executive orders were still rules promulgated under legislative authority. So what the amendment did was sort of clarify what was already true, and I don't know if you can have this sort of reverse legislative history for purposes of answering this question. The governor had authority under state law to issue the mask mandate and the 10-point plan, and that's what the plaintiff complained about.
Legislative history, someone said within the legislative history that this was a clarification of the statute, correct?
Sure, but the legislative history in our brief points out this was all about COVID. This was March 2020, and we all remember how dangerous things were at that time. And so when the plaintiff told management, you know, your son is running around, he doesn't have a mask, and management, we know from the allegations in the complaint, was hostile, to say the least, in response to plaintiff's complaints, and he was ultimately fired over this, you know, that makes out a claim for whistleblower retaliation. As Your Honor pointed out, this is a notice pleading state, and the allegations permit the inference that plaintiff was fired because he blew the whistle on a serious public health and safety violation, and there really can't be a dispute that there's a serious public health and safety violation when somebody's in the building in early 2020, pre-vaccine, not wearing a mask, running around and yelling at people.
Well, that may be true, certainly in the abstract, but how do you answer your friend's point that the one or more of the executive orders on which you're relying were not promulgated or effective until after the whistle was blown, so to speak?
Here's the executive orders and rules that we're relying on. Executive Law Order 202.17, that's April 2020, plaintiff is still working there. The 10-point pause plan, that was March 20th, 2020, and OSHA. We have an OSHA violation here, that you maintain a workplace that's free from any health hazards. These were all in place at the time that plaintiff was blowing the whistle, and the business owner was hostile to plaintiff's complaints. So those are really the
So
rules.
you're not arguing retroactivity for the amendment that was made to 740?
I don't think I can, but we still have 3 rules in one law, 2 rules in a law that's predicate the basis for plaintiff's whistleblowing. So this court, we ask this court to affirm. Thank you.
Thank you.
Again, it is clear from my colleague's presentation here that the plaintiff, Appellate in this case, is relying on executive orders that did not bar the conduct that's being alleged here. Again, the complaint references 202.8, which does not even mention face masks or social distancing. The complaint references Executive Order 202.17, which again is applicable to individuals, not to a business employer. Again, that statute that required business owners to remove individuals, non-compliant individuals, did not come until after the plaintiff's employment.
So your employer had no obligation to control the conduct of his son in the workplace?
He was a non-employee, and no, not until after July 9th, 2020. If
So
this
you
case
say
had-
he was a non-employee. Why then would he have been authorized to be on the premises, the workplace, every day? He's a non-employee. What is he doing there?
He was not in the workplace every day. He was in there, the complaint says, on a few occasions. And in fact, there was only
So why would he be authorized to be there on few occasions, not wearing a mask and not socially distancing?
You used the word authorized. He was never authorized to be
What
there.
was he, are you saying he was trespassing?
Right, exactly.
I'm
If
not
he's
saying-
not an employee, right, and I used the term authorized, so my question really was, so therefore is he a trespasser?
He was not authorized to be there. Mr. Wims, Todd Wims, did not invite his son to be there. And again, in every
So he
single...
was trespassing, and yet his father, the employer, did nothing to prevent a trespasser from being on the premises with the employees.
Again, every single instance, Mr. Wims had asked his son to leave, except for one instance. And again, that one instance does not amount to a practice, because we need to have a practice in order for there to be a violation of Section 740. And again, it was not a violation of the statutes that were in effect at that time.
Thank you, counsel.
Thank you.
Okay, People versus Curley.
Good afternoon. May it please the court, Heidi Bota of the Legal Aid Society, appearing on behalf of Sergeant Corey Curley. In his own letter to the lower court prior to being sentencing, Sergeant Curley stated the following.
You're using the term sergeant. I mean, really?
I believe he earned that title, Your Honor.
Well, okay, continue. I'm sorry.
In his own letter to the lower court prior to being
That
sentenced,
didn't entitle him to carry a weapon against city regulations.
And to
right?
pretend to be a federal agent, I believe.
that's
But so
correct.
I'm not really clear what you're asking us to do. Is there anything in the record, in terms of reviewing the denial of the Clayton motion, is there anything in the record to sustain a finding that somehow the trial court or the motion court abused its discretion in taking on this extraordinary remedy of dismissing the indictment?
I would say what makes this case notably different, Your Honors, is that the trial court in its decision denying the Clayton motion twice stated that it would not be opposed to a misdemeanor
But the
conviction.
issue is whether or not the trial court abused its discretion. People v. Clayton, there are, I forgot how many factors to be considered. The trial court went through each factor, stated that they were considering those factors, and based upon their consideration of those factors, they were not granting the Clayton motion. So again, my question is, what in the record would allow us to find that the trial court abused its discretion?
I wouldn't say abused its discretion,
But
but
isn't
one
that
of
the
the
test?
That's the
factors.
standard, isn't it?
That's the test. I mean, that's the standard. And we'd
One
have
of-
to find that there was an abuse of discretion, right?
You could also find that one of the factors that the lower court decided this motion on was the fact that it was not unreasonable to have Mr. Curley monitored based
That's
on.
But that was the view that the court expressed, and the court felt that it could not override the prerogative of the district attorney to charge a felony rather than a misdemeanor, right? That's why the court said, I would not be opposed to a misdemeanor.
Correct. The court even granted another adjournment after 2.5 years, but also lauded the extraordinary accomplishments that Mr. Curley had made during those
I
2
mean, clearly the court was sympathetic. You know, that's a far cry from abusing his discretion. I mean, other than forcing the district attorney, which I don't think the court had the authority to do, to lower it from a felony to a misdemeanor, I don't know what else the court could have done.
Well, the court did say that the main thing was to watch Mr. Curley's progression, that although he had made these extraordinary,
Which is hence why the court wanted it to be
him
brought
to
down to a
be-
misdemeanor, right?
and to be observed, to
Right.
see how long could he keep up, and it's been now 7 years.
But see, that's the
Since
point.
his
People
arrest.
v. Clayton does not allow a court or judge who is sympathetic to a defendant to simply say, you know what, I feel sorry for the defendant. He's going to lose his GI benefits. You know, he served our country, and we should take that into consideration. Clayton doesn't talk about any of that. And where he may, again, be sympathetic, it does not allow him under People v. Clayton to grant a dismissal of the indictment.
True, that's very true, Your Honor. There is one, that's a whole nother, I see I'm almost out of time, but it's also the reason why the Veterans Court, which I go into in my brief in detail, was enacted. And this was only 6 months.
You know, again, you know, I saw that in your briefs, I saw that in your argument. That is something that should have been brought up, you know, in the initial stages, after the defendant was indicted. Perhaps the defense attorney at that point in time would ask that the case be transferred to Veterans Court. But again, you know, we're talking about the factors under Clayton, and we're talking about whether or not the trial judge abused its discretion.
I believe it did. I believe also that not only did defense counsel, it's all over the record that defense counsel asked on multiple occasions for it to be sent to Veterans Court.
So it's an
Court
abuse
itself-
of discretion because it was not sent to Veterans Court?
I believe it's abuse of discretion on the people's end. Yes, Your Honor.
But People v. Clayton, that's not, again, what we're talking about. I mean, you know, it's not the people that we're talking about here in terms of whether they should have offered the misdemeanor. Maybe they should have, but, you know, that's not on the court.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court, Carrie Fulham for the people. This court should affirm the denial of defendant's Clayton motion because by agreeing to plead guilty.
Why did he have such deaf ear to the court's statements that a misdemeanor would have probably be the better result in this case? I mean, you're talking about someone who served the country, clearly made a mistake, clearly was advised by his uncle who's on the force that he should not carry a weapon into the city, particularly in a federal building.
And acknowledged possession when he came
Right.
into the building, right?
Right.
He said, hey, you know, I have a weapon.
So we get it, but why is a felony the proper result here?
So Justices Acosta and Weber, you both are reaching the merits of defendant's motion, and of course I will answer that briefly, but I just want to say that there are 2 procedural bars here preventing this court from reaching the merits, and that is the fact that defendant pleaded guilty and separately executed a written waiver of appeal. However, in discussing the merits, 2 points in response. First, what we see from the record is that the people declined to send this court to declined to send the case to Veterans Court. We don't have on the record the reasons for why the people made that decision. So defendant has not fulfilled his obligation in making an adequate record for review, for appellate review under People v. Kitchen. But more to the point, Justice Obis correctly observed that that court was without the power to unilaterally force the people to consent to Veterans Court treatment.
And we agree. I'm just interested because I keep reading how this district attorney's office is dealing differently with cases that are filed that he decides to follow or pursue. I mean, this seems to be a case where the court itself is telling you, you know, maybe a felony is not the proper result here. Maybe he should be monitored. Maybe we should try to reach a different, you know, a veterans court is created, it's a problem-solving court created particularly to deal with this kind of stuff. So I'm just not getting it.
Your Honor, 2 points in response. First, defendant already received significant leniency here, and that is because by virtue of under the penal law, he was actually required to receive mandatory jail time. But instead, the people, considering all the mitigation defendant put forth in his Clayton motion, allowed the defendant to receive a probationary sentence instead. And that actually required a special finding by the judge. So the people, they were not deaf to defendants' arguments. They considered those arguments and appropriately acted on them, granting such leniency. But the second point, and I think this is really the heart of your question, Justice Acosta, is defendant deserved a felony conviction here. And that is because the offense was serious. The circumstances of the offense were alarming. He presented himself as a federal law enforcement officer when that was factually untrue. He brought a loaded weapon into the city after being told not to do so. He had a pattern of serious misconduct in the military where his—
Counsel, was he on leave from the NASA Police Department, or had he been suspended at the time of the incident?
He was terminated. He was terminated. It was about 6 weeks where he did not receive pay from NASA. NASA told him do not report to work, and NASA confiscated his badge. Now, even if we—
So he was using his twin brother's badge.
That's correct. And so even if we take him at his word, that he didn't realize he was fired and he believed he was on administrative leave, one, I would say that that is not supported, that is not credible. But even if we give him some leniency, the fact is he represented himself as active duty law enforcement. So even if he was on administrative leave, according to his own beliefs, that was still a misrepresentation, that was a lie.
Do we know why the feds didn't take this? I mean, it's a weapon in a federal facility. I was wondering, do we know, is there anything in the record as to why the feds didn't prosecute?
No, the record doesn't speak to that. No, so just getting back to the point, he was deserving of a felony conviction. The poor judgment he displayed here was not an aberration in his military career and in his career outside of the military. So
It may be, though, that a veteran of a foreign war who served in hazardous capacities, his background experience and what he was experiencing therefore as a result of that, Veterans Court would have been the more informed forum to judge his conduct.
Your Honor, that was a consideration. That I see my time has expired. May I
You
briefly—
can go ahead. Please answer.
So prosecutors review both the charge and the character of the defendant when determining whether to divert the case to Veterans Court. In this case, we know the prosecutors, after making that determination, declined to send the case to Veterans Court. But just to briefly sum up, even if we take defendants' mental health symptoms and diagnoses at their word, there's no causal connection in the record establishing his diagnoses to the decision-making he did here. But even if we take that at his word, his symptoms like hypervigilance, poor judgment, poor impulse control just show why it's dangerous for him to possess a loaded weapon in New York. And for those reasons, the people ask this court to affirm.
Thank you, counsel.
Thank you.
I would just like to know that he did not believe he was terminated. He believed he was suspended from NASA, and that at the time, yes, he did display poor judgment, but he was 6 months.
Why was he using his brother's badge if he thought that he was
Because when he
still-
was suspended, they took his badge, Your Honor. And he was only 6 months into civilian life after 16 years of service, 10 in Iraq and Afghanistan, where he was the victim not only of 4 IED explosions, his job was one of the most dangerous jobs there, which was dismantling these explosives. And my brief cites all the things that he had seen.
Could the Clayton Court have taken into consideration all of those extraordinary circumstances on the one hand, his service in Iraq, balance them against the remaining Clayton factors, and rationally concluded that on the in the totality of the circumstances, Clayton relief was not warranted?
I believe that they would not have done that, or they were afraid to do that because they wanted him to be observed for a period of time. And now he has successfully completed probation. His Delaware probation officer just put in an interstate request to discharge him from probation. It's been 7 years since his arrest. He no longer even owns a weapon. He is working, and this felony conviction affects many things, like I said in the brief, but mainly also the fact that all he wanted to do was serve and to continue to serve. And I would just say that there is precedent for this court to reduce it to a misdemeanor. Thank you for your time.
Thank you. Thank you both. That's a terrible case. Carling versus William Gottlieb Management.
Good afternoon, Your Honors. Eric Baum from Eisenberg and Baum. Thank you, and may it please the court. The attorney-client relationship is sacrosanct, and the retainer agreement must meet the requirements not only of basic contract law.
Why isn't this retainer agreement like the one in Atkins, which was basically getting counsel to be paid for general availability?
Well, in Atkins, Your Honor, the court specifically held that there must be one of two requirements that are met. So there must be either a detrimental reliance on the part of the attorney, or there must be a general retainer agreement entered into for a fixed period of time, and the services are performed during that time frame. Carlin has acknowledged that he did not detrimentally rely on the contract, and the fees that he is seeking here are post-termination. He essentially suspended his services, did not give any notice, and then said, now I'm invoking a 90-day termination clause and I need to be paid. And there's no case that was supported by Mr. Carlin or the court below that stands for this proposition that a attorney can recover for fees that are not earned. In fact, there are disciplinary rules that specifically apply in this circumstance. And if you look at the Cooperman case, which was cited, that was a very similar situation where an attorney was disciplined for trying to collect.
Yeah, but the concerns that were expressed by the court in Cooperman, basically that plaintiff will get a windfall for being paid for basically not working. I mean, those are not present here, right? He's available for 20 hours and was certainly utilized for those 20 hours until there was that dispute about not being available, about being someplace else.
I mean, there is just no case on point, Your Honor, where we're looking at, the sophistication or where we're looking at a situation other than where those two requirements are met. And I might even point to disciplinary rule 2110A3, a lawyer who withdraws from employment shall refund promptly any part of a fee paid in advance that is not earned. So there's just no case law to support it. And if this court were to create a new exception, it shouldn't do so on a summary judgment motion, and this would also create a slippery slope where there's no bright line rule.
Counsel, hypothetically, October 24th was the day that Mr. Carlin said, I'm not working anymore, you guys haven't paid me my bills.
Correct.
And then you fired him, right?
Correct.
Now, hypothetically, could you have not fired him and continued to give him work for the remaining 90 days?
Well, the problem, Your Honor, is that there was a dispute in what the fee should be. Back in September, October and September, there was an argument about whether his fee should be reduced to $10,000 per week. I'm sorry, $10,000 per month versus $10,000 per week. So there was a breakdown in the communication. Carlin continued to work. So it was kind of a catch-22. If the
Well, you can't unilaterally change the contract, right? Neither side can. It was $9,000 per month, right?
It was
per week.
It was $9,000. Then Mr. Carlin unilaterally changed it to $10,000. But then there was a fee.
Well, he can't do it either, right? A contract is a contract.
We've submitted an expert.
I mean, there wasn't a meeting of the minds at $10,000, right?
Or was there, I mean, didn't Mr. Bender say somewhere in an email that 10K is okay by me?
Yeah, that's not really an issue here because Mr. Carlin has abandoned that issue. But the point is if this is not your general contract, if in an attorney-client relationship, when there is a dispute with your client, you have to reconcile it. You cannot just continue to work and try to build up the rate because you have a contract that
Well, the
applies.
client was an attorney as well, right?
He was not.
The client was an
He
attorney?
was not. He went to law school. He never practiced law.
But he wasn't unsophisticated, right?
Well, of course he was sophisticated, but the cases that apply the rule of sophistication have no bearing. There's no case that says you look at sophistication in the context of post-termination fees. So sophistication is a relevant concept. You know, there is some case law that's supportive of that, but in this context, where you're talking about post-termination fees, there's just no case that is on point. In fact, the Court of Appeals has set forth the two exceptions in this circumstance, and if you're going to make a different exception, it shouldn't be done on summary judgment. There should be a fuller record.
Thank you.
Good afternoon, Your Honors. I'm Alan Carlin. May it please the court. As Your Honor indicated, a contract is a contract. And this is a general retainer agreement, unequivocally a general retainer agreement where I was required to provide my availability.
Requiring you to be around for 20 hours.
To be, at their request.
For a specific amount of money, right?
Yes, correct.
So you can't unilaterally change the amount, right?
Correct. They cannot
So you've abandoned the issue of 9,000 to 10,000, right?
Exactly. Yes, Your Honor. And it's a complete and clear agreement, as the lower court said. There's an exception to the general rule that that a client can terminate an attorney's engagement at any time for any reason along the way. That's applicable to a special retainer agreement. It's not applicable to a general retainer agreement. And that's been the law in this state for over 100 years. And it was reiterated in the Atkins decision. And what you have now is a contract that should be enforced. It's not a question of quantum merit. It's not a question of reasonableness. It's a question of what the terms of that contract are. I made a commitment to be available for the stipulated amount of time in exchange for a stipulated amount of fees. And in addition, the defendant agreed to give me 90 days' notice before terminating the agreement. That is a contractual term. Here, the defendant stopped paying me. I told the defendant,
you agree. I mean, we have two experts that, formerly high-level folks within our own department, our own disciplinary committee, that disagree about, for example, the 90-day termination provision, which at least Mr. Maltz thinks it was a blatant violation of ethics.
Well, Mr. Maltz just disregards the Atkins decision and disregards that whole line of cases that holds that the general retainer agreement is an exception to the general rule applicable to special retainer agreements. There's no basis whatsoever.
You agree with your expert, Mr.
I certainly agree with my expert, and the Court of Appeals agrees with my expert, and this court has agreed with my expert in the past. And there's a situation here where I have made this commitment.
And so then the bottom line is whether or not you performed your duties under the contract and whether there are any issues of fact to the contrary.
Yes, Your Honor.
So did your adversary present anything showing that you did not perform your duties under the contract?
The only allegations were of a conclusory, generalized.
Well, you were in Woodstock doing whatever you were doing in Woodstock.
There's not a single instance, Your Honor, of an allegation with any substantiation that I was not available to render services.
I think you presented logs, you presented other
Daily
documentation.
reports.
Right. And so was there anything presented contrary to that, to contradict what you presented?
No, Your Honor. As a matter of fact, in their bill of particulars were I asked them to identify with specificity all items of my alleged breach or deficient in performance. Counsel for the defendant alleged that I wasn't available, that I voluntarily agreed was not going to be available Mondays and Fridays, and stopped rendering services on Mondays and Fridays. And as reflected by the record and in my brief, there's a boatload of emails and daily reports on Mondays and Fridays throughout the term that makes that conclusively belies and refutes that allegation. It's one thing after another that's been fabricated here without one thread of substantiation whatsoever. Nothing.
Didn't their own defense witnesses more or less could not come up with any evidence to counter
So
everything?
their designated deposition witnesses both testified that they were not aware of any facts that would support a claim that I was not available for the 20 hours a week or ever declined to render services that were requested. Both of them so testified. There's nothing to the contrary in the record to substantiate anything other than that. And that's what Justice Cohen recognized. And that's a fundamental rule of summary judgment. God, I don't want to be saying the obvious, but the defendant has to lay bare his proof and substantiate his claims. They haven't done that here. It's a breach of contract action based upon over 100 years of precedent in the Martin versus Camp case, 1916. It's been reiterated over the years. A general retainer.
We've had some more recent
Yes,
cases.
the Atkins case.
in this
And, Your
department.
Honor, yeah, there are, it's a standard provision in general counsel agreements for there to be severance provisions, for there to be notice provisions, and the like. For this court to declare that those agreements are unethical and not enforceable, I think is just ridiculous.
Thank you, Mr. Carter.
Thank you, Your Honors.
Your Honor,
So, counsel, what therefore would be the issue of fact as to whether or not there was, that he did not perform the duties under the contract?
Yeah, so Your Honor, Mr. Carlin made fatal errors during the summary judgment phase, and we've cited them in the reply brief, and they're on page 650 and 652 of the joint appendix. We specifically, in the uncontested statement of facts, we set forth specific testimony from Mr. Bender, how he was unavailable, how he could not be.
Mr. Bender was the one who said that he must be in Woodstock or something. I mean, that she was told. And then Ms. Cosme, who was the designated witness, she said she didn't know of any instances where he did not perform under the contract.
Well, Your Honors, Mr. Bender testified that he was not around, he was not there 5 days a week, that he was interfering with business.
Based upon what?
Based,
I mean, what was
it was
his statement?
it was his testimony in the record, Your Honor, and there was even a text message, which is part of the record, in which he said Mr. Carlin has not been able to be located for the last 8 months. That's
But then
that's cited in the reply brief.
Mr. Carlin's records indicated that he had been doing work for that period of time.
The only thing that Mr. Carlin submitted were summary reports because the appellant had requested that he provide just a list of things that he was doing. He specifically generally denied allegations. He gave no specific allegations to refute that he was available in the summary judgment phase of the motion practice. If you look at that closely, look at the actual uncontested statement of facts. He said general denial, Neil Bender's testimony is not admissible, and there's no specifics that you can relate
But
to.
Ms. Cosme's testimony, your own witness is
Ms.
available.
Cosme was the comptroller, so the controlling witness here would be Mr. Bender, who had this specific dealing.
But that was your designated witness. You designated her.
Yes, she was designated because it went to the issue of how much money was outstanding in the billing, but Mr. Bender was a fact witness as to Mr. Carlin's availability.
Okay, thank you. Thank you both. Kirby versus Carlos Bakery.
May it please the court, Stephen Bergstein for the plaintiff appellant,
Double duty today, huh?
triple duty.
Triple duty.
And I want to use my limited time on this case to talk about the two primary claims, the racial discrimination and the overtime claim.
I mean, you label the discrimination claim as a hostile work environment, but that's just a straightforward discrimination claim, which at this stage, we able to accept, correct?
Correct. We don't have to specifically identify the precise nature of the cause of action in a complaint under New York law. If there's an allegation of wrongful discharge based on race, in the statement of facts, that's enough under the New York pleading laws. So, you know, the facts here on the 3211 is the plaintiff worked for the bakery. She went over management's head on a work-related issue. She went to HR. Pernini, her boss.
So your claim is that the reference to her race by Mr. Pernini is sufficient to raise an inference of discrimination?
Yes, that and his saying out loud, "I never should have hired her." And
saying what?
he said, "I never should have hired her."
I never should have.
Right, and then she's fired.
Referencing her race.
Right, and she's fired a couple of days later, and that makes that a prima facie case. We don't have to get into issues of pretext at the pleading stage, but I do point out.
Counsel, does it matter whether Mr. Pernini fired her or HR fired her?
Well, the complaint says he fired her. That's paragraph 6, that Pernini made the decision to fire. That's record 9, paragraph 6. But, you know, he was her immediate boss. Even if we didn't have that allegation, the inference would be that he played a role in her termination. And under 3211, we can accept that as true. At a minimum, race is a motivating factor here since he was the immediate supervisor. And as soon as he made the comment, "I never should have hired her," and he made a comment about her race, she was fired.
Sir, how do you respond to your friend's argument that the reference to her race in that particular offensive response to her was a stray or isolated remark, and therefore not actionable under the race discrimination laws?
Not if he's talking about it in the context of whether he never should have hired her. And, you know, if it's a stray joke 2 weeks ago from somebody else, that's a stray remark. If it's the decision maker makes a reference, a derogatory reference to her race, that's not a stray remark. That's direct intent. That's direct evidence of his discriminatory intent. The law is clear on that. Very quickly, on the overtime claim, the pleading standards in New York on wage and hour is not governed by the Second Circuit Lundy ruling. It's governed under New York law, which is just straightforward notice pleading. About a month ago, the Second Department addressed this identical issue in the Gutierrez case, and I can give you the site. It's November 9th, 20.
So your argument is we should follow Gropa and we should follow Gutierrez, right?
Correct, and that it's enough for the plaintiff to allege that she was denied overtime, she was denied extra pay for the additional 40 hours. Thank you.
Hold on,
Hold on,
counsel.
hold on.
But was the plaintiff an exempt employee under the defendant's employment handbook?
No, not based on the allegations in the complaint. Defendants in their opposition brief didn't actually address those defenses. We addressed them in our opening brief, and then defendant didn't deal with it at all. Their primary objection to the overtime claim was that it was insufficiently pleaded and that it was too vague. But we did affirmatively say that she's not exempt because she fell within the hourly or the weekly paycheck threshold, $1,125 a week. She was doing at least 25% manual labor. So not only do we allege that in the record, but defendants haven't really addressed that issue on appeal.
Okay, thank you.
Good afternoon, Your Honors. If it pleases the Court, Joseph Dimitrov, Litchfield Cavo, on behalf of the defendants' respondents in this matter. As Your Honors are aware, this is a pre-answer motion to dismiss. We're here to discuss the actual pleadings contained in the four corners of the complaint, as well as those raised in the supplemental affidavit that was presented in opposition to the motion. Quite frankly, putting both together, the pleadings are deficient across the board. Plaintiff argues that there is only required a notice pleading, but misconstrues what a notice pleading actually is.
Well, that's what big is, right? All they're required to do is give you notice of the claims that they're making. I mean, they're claiming that under the state she was adversely impacted on the city, she was disadvantaged by firing her under a statement referring to her race, which at this stage, I mean, the reference to her race seems to be sufficient to raise an inference of discrimination as Big versus Hairspray said, as Bennett, as Williams, and all of the cases out of this department.
Well, Your Honor, the statement, if true as alleged, is simply
Well,
not...
we have to take them as true.
Correct.
Right?
But it's not enough to bring forth a race-based animus in order, even in the pleading stage, in order to put forward any type of discriminatory...
Well, usually you don't, you know, I agree that it could be interpreted usually as a stray remarks, but in this case, it was in the actual statement made when she was disadvantaged or fired, right?
She was fired by HR, as alleged by plaintiff in the complaint when she called in sick. She wasn't fired by John Pernini, who allegedly made the statement.
Well, to follow up on Judge Acosta's point, what is the materiality of the temporal connection between the statement and then the adverse employment action?
For a discrimination claim, none. The temporal proximity only comes into play if it's a retaliation claim. Temporal proximity in regards to this discrimination does not give rise to a race-based animus in this type of pleading.
Well, it raises an inference, right? That's all that, I mean, why were you, what is the relevance of her race if what the underlying complaint is that she went to HR?
I don't believe that her race takes a part in this.
But he said it.
Why?
But he
But
brought
he
it.
said it.
He brought it to the. I mean, he was the one who brought it up. The night before she's terminated, he says, "Why did you call HR? Blacks. I should have never hired her." I'm not understanding. Why would that not lead to believe that it's not a stray remark? It doesn't make. He brought it up. He said blacks. He didn't say, "Why did you call HR? I should never have hired her." I mean, he said blacks. I should never have hired her.
Even assuming that he did say blacks, I should have never hired her, he did not fire her. Plaintiff does not allege that he fired her. Plaintiff alleges in both the complaint and the affidavit that HR fired her after she had called in sick.
Okay, that's...
Failing to make the allegation in the pleading is sufficient to dismiss the complaint in its entirety.
So he as the owner has no impact
He's a supervisor of the
on
premises.
HR.
He's a supervisor. There's no allegation that he contacted HR when she called
Well,
in sick.
but that's what
There's no allegation
discovery is for, right?
Yes.
And plus, there was clearly some communication between himself and HR because he knew about the conversation she had with HR, and he didn't know that from her.
And the case law simply says giving a
yes.
rise to an inference of discrimination. So why does not his having a conversation or his knowing that she had a conversation with HR, that bringing that to her attention and then saying, "Why did you call HR blacks? I should have never hired her," and then her being terminated the next day, why would that not lead to an inference of discrimination? Again, keeping in mind that it's a 3211 motion.
There's logical breaks within the allegations that break down the inference. The inference that the plaintiff would like for this court to reach requires a stretch of the imagination. It involves
I don't think it's much
John
of a
Pernini making the
stretch.
statement, John Pernini...
I don't really see how it's a stretch. What is the stretch? Where are we stretching from?
Because John Pernini, as the supervisor, is not alleged to have fired her. John Pernini is not alleged in the complaint or the affidavit to be involved in the firing process, only in the communication that took place between the two of them the night prior. And if I may just briefly address the fact that this liberal construction, even on a notice pleading under both for race discrimination and the overtime claim raised by plaintiffs, is not a meaningless standard.
He does allege, the complaint does allege that he was irritated by her prior conversations with HR, and that's why she was ultimately terminated. So is that insufficient as well, those allegations? Is that also a stretch?
That is what the respondents hold because it is not alleged that he was involved in the firing, in the termination at all. It is simply not alleged.
We have to afford her the benefit of every possible inference, right? Favorable inference. That's what we're talking about. You want us to make findings with respect to her allegations. We're not there. That's not the pleading stage.
I understand, Your Honors, and I would simply leave the court with this, that based on how the complaint was alleged and the allegations contained in the affidavit, taken together is simply not enough even to rise to the minimal level of a liberal reading under any of the causes of action that were dismissed. Thank you for Your
I
Honor's time.
understand your argument.
Just so we can clear this up, page 9 of the appendix, paragraph 6, at all relevant times, John Pernini hired plaintiff, determined her rate of pay, directed her day-to-day work, and ultimately terminated plaintiff. It is not a stretch to...
Well, HR terminated her.
Well, HR is probably the one who makes, the paperwork, but certainly the inference is that Pernini influenced her termination.
Your adversary is claiming that there's nothing in the complaint which says that Pernini actually contacted HR and directed HR to terminate her.
But it says ultimately terminated plaintiff. That places him at the heart of the decision-making process. Even if he influenced HR to fire, and he did so on the basis of race, that's the discriminatory link in the chain that permits an inference of race discrimination. The cases have held that. Second Circuit holds that, and this court holds that. If he
Don't cite the Second Circuit, because they've adopted our decision, so.
But even they recognize that if you influence determination based on your own, it's cat's paw, basically.
Okay.
And so it's not a stretch to infer.
We got it. We got it. Thank you. Thank you both.
Second Circuit is big.
Lefkowitz?
Okay, again, Stephen Bergstein for the plaintiff appellant. This is an age discrimination complaint. We don't have direct evidence here. We don't need direct evidence in a discrimination case.
So what are the circumstances that give rise to an inference of
Okay.
discrimination in this case?
Lukowitz worked for the hospital for 34 years. He did so successfully. There were never any problems. There was never an allegation that he had ever engaged in racially offensive behavior. He was 79 years old. A new medical director comes aboard. She undermines his employment without any rational basis, and he fights to get his job back, and she had no authority to do so. And he comes back to work. Then there's an incident, and they use that as a pretext to terminate his employment. And the facts, we have to pay close attention to the facts here. He had a photograph on the reverse side of his ID card that he intended as a joke. No one was ever offended by
I
it.
did not understand that. So where in the complaint, or where is it that there is any evidence that because he had this photo in his as his ID, that this somehow caused his termination?
Well, he was let go. They seem to be arguing that he violated workplace protocol in showing a security guard this ID card. So I think for purposes...
So let's assume that they wrong about that. Would that make it a prohibitive ground to dismiss him under the City of State Human Rights law?
If it's not a logical decision on their part. He didn't affirmatively show it to the security guard. Defendant's brief suggests that he showed it to the security guard. No, the security guard took his normal ID, flipped it over, and saw the picture, and they're claiming that the security guard was sufficiently offended and complained, and plaintiff got fired for...
So they thought it was an insensitive joke.
Right, but he didn't affirmatively show it to the security guard. So if he didn't do anything wrong the day he came in with his ID card, and then they use that as an excuse to fire him...
So that was a wrongful termination. I'm trying to get to...
Where's the age?
The age.
All right, the age is that they already tried to get rid of him once. It didn't work, he came back.
Not based on his age. They tried to get
but-
rid of him because they didn't like him or there was disagreement, whatever the reason. Those reasons are not prohibited by the state or city human rights law.
True, but this is not a summary judgment motion, so we don't know,
I'm trying to give you the
right,
the benefit of
his
the
age,
pleading, of
his
the
age,
standard.
his age, his longstanding successful employment there, that's a prima facie case, a wrongful discharge.
But
No.
what about his age? I mean, no one said anything, oh, you're 79 or whatever, you can no longer perform, or you're an old fogey, or, I mean, there's
Yeah.
no reference stated in the complaint that I saw of any to his age.
I mean, there weren't even any straight remarks with respect to his age.
You don't need
As you
that.
had in Melman, for example.
You don't need,
In which I dissented, right? That, I've been looking for what the nexus is to his age, and I haven't found it.
you don't need comments about his age to make out a prima facie
What,
case.
don't you need some mention of his age somewhere?
Yeah.
Not in a traditional disparate treatment claim based on age. If you're qualified for the job, you're fired under suspicious.
So we're assuming that because he was quote-unquote qualified for the job, because he had been there since, 1983, since he was there since 1983, he's quote-unquote qualified for the job, therefore, because he's terminated, it has to be his age?
If he's terminated under suspicious circumstances.
Right, well, but that's what we're trying to get to, right? What are the circumstances that give rise to an inference of discrimination?
Right. Was
Whether
it-
based on his age or based on any other protected category.
Because he didn't do anything wrong. And because
So you have a wrongful termination claim. Why is that a basis to proceed under the city or state human? Those are anti-discrimination.
prima facie claim, all you need is qualifications. He's within a protected class. He's fired.
I'm familiar with
I
Bennett's
know.
standard because I wrote it. What are the inference?
And it's a minimal burden to plead.
It is minimal.
But you gotta say something other than he was 82 years old or he's 79 years old. There has to be something else. I mean, was the picture of the monkey, was it an old monkey? I mean, give me something.
Wasn't an old monkey.
Give me something.
There's something.
Was it an old monkey?
The something is, we know that to make out a prima facie case, it's minimal, and if he makes out.
Minimal, but something.
He
Minimal
makes-
does not mean.
I mean, remember what we say in Williams? I mean, this is not a civility statute, right? That was a statement that was made on the Title VII in a different kind of case. We're not averse to, I mean, not we, I mean, we're interpreting what the city council's policy choices are, but you got to give us something. Not every termination is done based on prohibitive.
But under 3211, if it's an illogical termination, and again, I cite to the Second Circuit, firing somebody
There
for.
has to be a nexus to a protected class, to a protected
Right,
category.
and he's 79, and he's fired for an
Yeah,
illogical.
but just being a member of that class doesn't mean that that's the basis for the decision.
It can.
Otherwise, we all have a claim anytime anything is.
No, because you might not survive the pretext analysis then. See, you can make out a prima facie case, but not prove pretext. We don't have to prove pretext in the pleading. All we have to do is show.
No, you don't have to, you don't have to prove pretext. All you have to do is show that he was disadvantaged under the city law or the adverse employment action under the state law has some connection or was done under circumstances giving rise to an inference of discrimination.
And the cases say that firing somebody for an illogical reason that makes no sense can create an inference of discrimination.
It can, but not always.
But
It can when, listen, we're not fighting about a stray remark that was made by a supervisor about his age. As in Melman, you had what was considered, I didn't think it was straight. That's why I dissented, right? The majority disagree. But there's got to be something that connects it to a protected category, and we haven't. I mean, a remark made about, when you reach a certain age, we sort of lose it a little bit, okay.
well, they tried to get rid of him previously for reasons that didn't work, and he came back and he was able to.
But those had nothing to do with his age.
But somebody new comes aboard and tries to throw him
Well,
out.
somebody new comes aboard, they want to change the workplace around them. There are laws that prevent them from doing that altogether, but
Then we have.
they can't do it on, let me get rid of all of the Latino workers, let me get rid of the young or the old or, any of the protected categories, but
Then we
there's
have.
some prerogative that an employer has to change the workplace.
Well, then we have a dispute about motive. Why was he let go? Was he let go because they don't think he's a good doctor, or was
But
he
you
let?
don't say anything in the complaint. All you say was 79 years of age when he was terminated. He was a great physician. Everybody loved him. He had a wonderful rapport with his patients and staff, but nothing about, that the reason that he was terminated was because he was 79.
Well, if he's all those things, if everyone loves him and he has a successful career there, why would they let him go?
That's a good question.
But
Why do you think that age had anything to do with it?
That's the question for discovery. Why else?
it's not. You gotta-
Unless we're going to assume that they just fire people for no reason at all and say, you know what?
Or for wrongful
Which
reasons.
they can.
Which is legal.
Which they can.
Which is legal, but that's not the inference you can draw on a Rule 3211.
Okay. All right, thank you.
Your Honors, may it please the Court, I'm Jessica Moeller from Von Schoeneck and King for the defendants' respondents here. And just picking up on the exact point that the Court left off with my adversary here, there is absolutely nothing alleged in the complaint that in any way connects the plaintiff's age of 79 with the fact that he was terminated. In fact, what the complaint specifically alleges is that this complainant, or this plaintiff, provided his ID to a new security guard. The security guard saw on that ID that there was a picture of a monkey instead of the plaintiff's picture. And in fact, the actual picture of the ID with the monkey on it is included within the record.
I don't understand why that's an insensitive joke. I mean, he says he was making fun of himself.
Yeah, he says,
Right,
when
that's
I
his-
was younger, I had more hair and I was much better looking. Maybe now you will remember me.
Yeah, why does that warrant termination? That's a pretty drastic remedy.
Well, in fact, this security guard that was presented with the ID was African American, and there's a whole body of case law that talks about the very offensive nature and the connection between monkey and ape imagery to racial issues there. But even without
You're drawing the same inferences, I think, that your adversary. If you see a monkey and you show a picture of a monkey to someone who's black, it's racist. If you fire someone who's 79, it's age discrimination. I think you're making the same jumps. I don't understand.
Well, but here, the law permits the employer to make that assessment, and the law permits the employer to determine what it believes to be not permitted and not acceptable within its own workplace.
I think the bottom line is that there's nothing in the complaint that states that the reason he was terminated was age-related. But, I mean, it could be wrongful termination if you're going to terminate him because he has the photo of a monkey on the back of his own photo for his ID.
Your Honor, you are absolutely correct. There's nothing in the complaint that connects the age with the actual termination decision. And quite frankly, if it was so-called wrongful from anyone's belief that he was terminated because of this picture of a monkey without the connection to his protected status of age, that is absolutely permissible and permitted by the law under this court's own rulings.
Well, how do you answer your friend's point that this is a CPLR 3211 motion on the pleadings, and that they tried to fire him or terminate him in the past, those efforts were unsuccessful, and perhaps this business with the ID, the altered ID, was simply a pretext to fire him now?
Perhaps that's all speculation, though. There's nothing in the complaint that actually makes the court or us to do that jump to get over the pure speculation and conclusory allegations that are in the complaint. And this court's own authority determines that speculative pleading, like we have here, is insufficient to state a claim and requires dismissal, even under the notice pleading standard of CPLR 3211. I don't have anything further. If you had any other questions, I'm happy to answer.
I think we're good. Thank you, Counsel.
Thank you, Your Honor.
I don't have much to add, other than...
Counsel, you're essentially saying that there's a void here and that the law sort of, abhors a vacuum. Like, we have all these factors. He worked there for a long time. She had tried to get rid of him earlier. It doesn't seem like it was a racist incident. So is there any case law that you can point us to that says that that void gives rise to an inference that it had to be his age, because all the other reasons, the framing of this makes it look like there's no reason to fire the guy?
Without a clear reason to justify his termination, if we accept that he didn't do anything wrong with the ID and he falls within the protected class, that satisfies the minimum.
What's your best case on that?
Oh, any of the cases under the city law that this court has issued that talk about, you don't need direct evidence, you don't need...
Well, you don't need direct evidence, but we Williams does talk about, this is not a civility code, they may have overreacted or become very oversensitive to, the stuff that he had on his, ID. But usually what we require is some previous, as remote as possible statement or allusion to the protected, there's got to be something on which we base the inference.
But
that's what Bennett says. That's what Williams says.
I know,
that's
but
what Vic says.
There's also the circumstantial evidence component of these cases.
Right.
When you don't have a comment, you don't have a mass termination of older people, you just have a senseless termination.
You have one, right, and that's it. If you had a comparative class, you say, well, this employer came in and all of a sudden, anybody over 65 seems to be dismissed. That may be a race an inference.
If we had that
employer, when she came in, she made a stray remark about how, she needs more young people in the workplace or people with more energy or like whatever, however you want to characterize it, maybe that raises an inference, but
I don't think there's a lot of cases in which dismissal is affirmed when the plaintiff falls within a protected class and is terminated for reasons that don't make any sense. That's my point.
I disagree. We do it all the time. I mean, we've adopted the very low notice standard that the city council created, but we haven't gone that low. That's why we created, trivia remarks don't qualify, et cetera, et cetera. But thank you, counsel.
Thank you.
Thank you both. Smartmatic. Oh, do we have a? No, I'm sorry.
Torres.
People versus Torres.
Good afternoon, Your Honors. May it please the Court. My name is Ivan Pantoja, and I represent Mr. Pedro Torres. We respectfully request that this Court modify appellant's risk level from a 3 to a 2 because the Court failed to appropriately consider significant mitigating factors that were not captured by the RAI. Now,
You're not challenging the assessment of 115 points, correct?
That's correct. Now, by no means do I wish to minimize the seriousness of the crimes here. They were certainly serious. But I do want to underscore that the purpose of the SOAR hearing is to determine Mr. Torres' risk of reoffense at the time of the hearing after the rehabilitative efforts that he went through. Now here...
But the seriousness of the underlying crimes can be taken into consideration, correct?
Yes, and they were...
Particularly in denying the motion for a downward departure or in upwardly departing, right?
That's correct. And in the analysis here, the lower court erred in finding that the seriousness of the offenses outweighed defense counsel's request for a risk level 2 determination. And the primary mitigating factor was his exceptional response to sex offender treatment. Now, exceptional response to sex offender treatment is specifically outlined as a mitigating factor that needs to be considered by the guidelines.
So that above all else should be the determining factor.
It shouldn't be the determining factor. It should be considered amongst other mitigating factors.
And what would the other mitigating factors be in this case?
The other mitigating factors are his lack of a criminal record, as well as his commendable conduct while incarcerated. Now, I think it's important.
And so, again, we're talking about two instances, right? Conduct with these children, his 8-year-old nephew and the other child. And so, again, seriousness of the crimes, but his exemplary conduct while incarcerated and his work with the sex offenders program, there should be a downward departure based upon that?
Yes, and I think the reason the guidelines specifically cite that as a significant mitigating factor is the reason why sex offender treatment is required. And the reason is because it significantly reduces the risk of reoffense.
Now, he was incarcerated during this period of time, is that correct?
Yes, he received a 15-year sentence.
15 years. How long has he been, how long was he in the community? How long has he now been in the community?
Your Honor, I don't have that exact release.
I think he was released in 2020, is that correct?
That seems correct, yes.
This is 2022. So he's been in the community now for 2 years, maybe?
Yes, and he has not reoffended.
In 2 years, that's excellent, kudos. But how do we know that that will continue to occur?
Well, I think because his response to sex offender treatment was so exceptional.
Right.
He received the highest.
Why was his response, I mean, why do you say it was so exceptional? I mean, how did he, how was it so exceptional in relation to other individuals who took part in these sex offender programs?
Well, I would say it's exceptional because it's extremely rare for individuals to score in the highest category in all of their evaluations, and also extremely rare for someone to get perfect scores on the majority
And
of
these perfect scores tell us that he will not reoffend, is that correct?
Well, I think the guidelines cite that as an exceptional, as a mitigating factor because the studies.
Yeah, but that just means he's highly motivated, not necessarily that his response was exceptional.
Well, I would say that if anyone's response could be categorized as exceptional, someone who performs near perfectly in sex offender treatment should be considered
So he
that.
did great. So like, you know, some people test well. So he did really well in the program. Does that necessarily mean that he's not going to reoffend? Again, as my colleague just stated, it shows he's highly motivated. He followed the instructions of what was stated in the classes. I'm not really sure how that leads us to conclude that there should have been a downward departure, again, based upon the seriousness of these crimes.
Well, I would say we should take the board for their word, as well as the scientific studies that do indicate that someone who does have such a response is less likely to recidivate. And just as a final note, I would note that because of his designation, regardless of the risk level, he's going to have to register and verify for his entire life. So downwardly departing would not affect that.
How old is he?
He is currently now
48.
He's 53. He was 48 at the time of the hearing.
Okay. So he's not of advanced age.
Well, he's advancing, and the studies indicate that once someone starts getting into their 40s and certainly into their 50s, the risk of reoffense diminishes greatly.
Okay. Thank you, Mr. Pantoja.
You are of advanced age.
I'm not of advanced age. I refuse to accept that.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court. Defendant was appropriately adjudicated a level 3 violent sex offender, and the SORA court's determination should be left undisturbed. He was already credited for his performance in the treatment program, and even assuming that his performance in the treatment program was exceptional, which the people hold was not, in part for reasons cited by you earlier, that simply cannot weigh the risk of harm that he poses to the community, both because of the type of harm he has already inflicted on members of the community and because of the risk he poses of reoffending. I mean, for instance, after he was arrested in connection with this case, He violated an order of protection, contacted one of his child victims repeatedly, and told that child that he loved him. And that all shows, Your Honors, that this man continues to pose a danger to society as appropriately reflected by his designation. If there are no questions, we ask that you affirm.
Thank you, counsel. Okay, you get 1 minute, Mr. Pantoja.
Your Honor, I just 2 points. One, I would just note that conduct post his first case was, of course, he didn't receive treatment during that intermediary period. And secondarily, I just wanted to thank Your Honors for your time.
Thank you. Thank you both. Okay, Smartmatic.
Your Honors, and may it please the Court, Paul Clement for the Fox defendants, who are the principal appellants, but we do have a cross appeal here today.
Good afternoon, Mr. Clement.
Thank you, Your Honors. Smartmatic's lawsuit against the Fox defendants strikes at the heart of the First Amendment and the broader protections for the freedom of the press in New York law and New York's anti-SLAPP statute. When the sitting president of the United States and his lawyers make allegations of fraud and indicate that the president's legal team will challenge the election results in multiple states, those allegations are unquestionably newsworthy. They remain newsworthy whether or not they seem plausible or likely to succeed. For that reason, every major news outlet in the United States—
Can't they be newsworthy and defamatory at the same time?
Well, the underlying comment, if the allegation— I mean, obviously I'm representing the Fox defendants here and not Mr. Giuliani. And so you could have a situation where the allegation as made by the person who's directly making the allegation is defamatory. But the question is when the press reports it, not for the truth.
Did the press, I mean, okay, I'd like to go on. Didn't the press endorse it as well in this case? So, for example, in paragraph 114, there's a quote from Ms. Bartiromo saying, quote, well, I mean, who's to stop this from happening again? I mean, you've got Democrats in charge from here on out. They're in charge of the machines. You'll never see a Republican in the White House again. So isn't that endorsing the alleged defamatory statements?
So I don't think that rises to the level of endorsing taken in context. And I think at a certain point you also have to allow for the protected opinion. In a case like Bryan against Richardson, you had repeating allegations that were similar to this in terms of their import and newsworthiness because they went to the validity of a presidential election and the like. But in answering your question, I do want to sort of separate out the question of endorsement from the basic question because, I mean, right now, you know, the way that this case is slated to proceed, all of this is going forward, not just particular endorsements, but the reporting itself. And I think that that's what's, I think you have to start with the idea that really you can't have the freedom of the press as we've understood it if you can't have the press reporting when the President of the United States makes allegations about fraud in elections or a governor denies sexual...
I agree with that general proposition, Mr. Clement. The question is, how far does that take you, right? You know, at what point is there an obligation to not endorse or participate in the very allegations that are being made, even by licensed attorneys?
That's a fair question, Your Honor, and I do think there is a question of degree here, but I think if you take the full context of this, there may have been one statement that you point out that I think is probably better described as opinion, but at the same time, every one of the Fox hosts that have Giuliani or Powell on the show, at one point they ask them, are you going to be able to prove this? What is your evidence? Generally, not with every show, but generally, and every one of the hosts at one point notes that Smartmatic or Dominion has denied these allegations. So this is not a situation where you have essentially a press organization that's just endorsing a particular theory. They are reporting it not because of really anything other than the fact that it is incredibly newsworthy that the president and his lawyers are making these allegations. And it's not just the
No,
allegations.
but what about when the anchors themselves, Ms. Bartiromo, Mr. Dobbs, are just repeating and endorsing what is being said by Ms. Powell and Mr. Giuliani? For example, how many states, breakthrough states, were using Smartmatics when the software and the company was only participating in Los Angeles County? Or, easily to verify whether in fact Smartmatics was created by Hugo Chavez with Cuban money. I mean, like, at some point it gets ridiculous. At some point, there's got to be some obligation on the part of the press to test the veracity of what are extraordinary statements being made.
So 2 responses, Your Honor. First of all, when they are being reported for their independent newsworthiness, I actually don't, I want to say that, there are indications here that would support that if that is the rule. But I don't really think that should be the rule when it's the president and his lawyers that are making these allegations, because if those allegations of fraud, and I'd say the same thing.
So that the requirement of whether the statements are false or being made in reckless disregard for the truth, there's a presidential exemption for that, or an exemption for counsel for the president.
No, what I would say is when these allegations are being reported because they are coming from newsmakers, sources that are inherently newsworthy, I think the right question to ask about the press's reporting of them, is it accurate? Not are the underlying allegations truthful.
Right, but after the 10th time that these individuals are invited to speak in these shows, at some point there's an obligation to, you keep saying you got all this evidence to back these allegations. What's up? Where is it?
And actually, that is what happened here, which is to say, these 2, Giuliani and Powell, were brought on these 3-host show. Probably if you tally them all up, it's like 9 or 10 times. In virtually every one of them, they were asking for the evidence. When are you going to be able to produce the evidence? When are you going to be able to prove this in court? And as the timeline goes on, those questions become more, I think, directed, because what's happening is not just are they getting tired of hearing the allegations, but these allegations about Smartmatic aren't just important in the abstract. They're important because the president's lawyers are saying they can prove this in court, and they can do it before the election will be final. And so as the calendar keeps going into, there's only one of these shows that was in December, everything else is in November. As November ticks on, the hosts are asking them, can you prove this? Or do you have any evidence? Where's the evidence?
If counsel, are you saying that if the statements that were continually made were bereft of any supporting evidence, if that was starting to happen, was there any affirmative duty for the defendants to do some journalism and check the facts, go to the website of the plaintiff, or look at its emails where they say we're only in LA County? Tell me, was there any obligation for them to do further investigation?
So if they are reporting these allegations because the allegations are newsworthy, I would say not. And my example of that, Your Honor, would be, to this day, former President Trump, as far as I can tell, continues to say that the 2020 election was stolen. Now, I think every news agency in the country can report the fact that former President Trump continues to believe the 2020
Right,
election
but courts are usually, last time I checked, we truth and facts undergird the business that we in. So at some point, and I assume that the press at some point incurs an obligation, even a well-protected press, as it is in New York, incurs an obligation to check those allegations being made, either by bringing others, certainly not by sort of repeating verbatim what is being said by counsel who claim that they have the evidence but never come up with it, even until now, or at least until the filing of the complaint.
And Your Honor, as a matter of fact, that is what happened, which is to say by December, We have Fox, every one of these hosts had on their show a segment from Eddie Perez, who was an expert on elections, who essentially did report and answered these questions and said, in his view, all these allegations were unfounded.
But you still continue to book Giuliani and Sidney Powell and others who continue to make the same statements. So, I mean, although you had Eddie Perez, you still had these other individuals still making the same statements.
With all due respect, Your Honor, that's not correct on the timeline. After Perez is on the show, these people are not booked any longer. And just to kind of put this in perspective, and this is why I think this is not an ordinary case. I mean,
no, it's certainly not an ordinary case. Right. I totally agree with you with that. I still don't understand. Is it your position that there's no obligation, or there was no obligation on Fox or on the various hosts to do any independent sourcing or look at anything or research to determine whether or not these statements were in fact defamatory or whether they were untrue?
I think the better view is there isn't that independent obligation because Fox is not reporting these as for the truth of the matter asserted. They are reporting this to give updates about the president's legal team.
So that's interesting. Is that stated? Do the various hosts, or does Fox, was there some type of disclaimer saying we're just presenting the statements by these individuals, but in doing so, we are not in any way endorsing their statements?
I don't think there is that kind of disclaimer, Your Honor, but that I don't think is what the law is required. And I think once you understand that what is being reported here, this is like the opposite of investigatory journalism. If you put this in sort of terms of the New York Court of Appeals cases, this is not gross, this is not front page news, A1, New York Times doing its own investigatory reporting. This is much closer to Bryan against Richardson, op-ed kind of materials, and what's being done here is they are reporting about very newsworthy allegations. And in that context, they are doing some of this independent, and they are saying, one of the reasons I think the trial court dismissed Judge Pirro is because in her very first interview with Powell, she started out by saying, now, Smartmatic denies this, or Dominion denies this. So this was never presented as like we've done sort of our own independent research, and here's what we've come up with. Most of these reports are taking place after Powell and Giuliani do this press conference where they say what they are going to prove to overturn the election results in these 6 or 8 borderline cases. Every news outlet in the country covers that press conferences, and then they bring them on the show in the wake of that, or in some cases just before that, and they say, what are your allegations? Are you going to be able to prove it? Now, to be sure, and I realize I'm at time, so I'll finish up.
I'll give you 30 seconds.
Thank you. To be sure, they are covering these allegations differently from the way MSNBC would cover these same allegations. But there has to be room in the freedom of the press to have one network cover this in a way where everybody's skeptical, and from soup to nuts, everybody thinks this is wrong.
I agree.
Another network. That's how you ultimately get to the truth.
I get you, but New York gives you plenty of room, except when you knew or recklessly disregarded was the truth, right?
But I would hope that your law would allow for the fact that that inquiry has to be sensitive to whether or not the allegations are being reported as kind of the results of investigatory journalism, or are they being reported because this is a huge news story because the President of the United States went on Fox on November 29th and said basically everything that Powell and Giuliani said.
Okay.
Thank you, Your Honor.
Thank you, Mr. Clement.
Good afternoon. Eric Connolly on behalf of the Smartmatic plaintiffs. The articulation of what took place here, as described by my friend, is not what is alleged in the complaint, and is certainly not what actually took place on these broadcasts. Let me step back very quickly, and then I want to get straight into the questions that you were asking, my friend. First, the allegations in the complaint make it abundantly clear that the way that the defendants pastured these anchors, Mr. Dabbs, Ms. Bartiromo, and Ms. Pirro is that they were sources of factual information that the audience should be relied upon. In fact, what these defendants did was that they positioned these three individuals as the people that should be relied upon above all others because everyone else is not telling you the truth. They did not frame these three anchors as ed pieces to try to invoke a Bryan versus Richardson situation. That is not what is alleged in the complaint. If in the course of discovery our allegation is proven wrong, summary judgment issue. But for purposes of right now, those are the allegations in the complaint in terms of how they were framed, and we actually back it up with citations to the defendant's own materials. These reports by these three anchors were not objective pieces. These were endorsement pieces of something that they knew was not true. Remember the allegations in the complaint, and we have 160 paragraphs outlining the actual malice.
Yeah, just with respect to Ms. Pirro, because she was referenced by Mr. Clement. I mean, your claim is that her statement in a monologue that, and I'm quoting, the president's lawyers alleging a company called Dominion, which they started in Venezuela with Cuban money and with the assistance of Smartmatic software, a backdoor is capable of flipping votes, unquote. That's the record at 1570.
Yes, sir. Absolutely. She is unquestionably liable for that statement. And she's liable for that statement for a couple of reasons that invoke black letter law. Number one, it is black letter law that the repetition or republication of a defamatory statement leads you to be liable just as if you were the original publisher of it. So the mere fact that she said, here's what somebody else said, I'm repeating it, does not get you out of jail. It is a republication of a defamatory statement, and you are always accountable for the republication of a defamatory statement.
But she doesn't know that it's, that the argument is that she's unaware that it's defamatory, or perhaps she doesn't even have to know that it's defamatory because she is in fact reporting the news.
Right, in fact,
newsworthy.
Right,
So,
in fact, she's relying just on that statement.
Right.
She's relying on, basically she points to the fact that the lawyers had offered evidence by ways of affidavit.
Yes, thank you. Brings up two really important concepts. Number one, we pled 160 paragraphs in our complaint establishing that Ms. Pirro acted with actual malice. Therefore, she knew or acted with reckless disregard in knowing that, one, there was no connection between Smartmatic and Dominion. So this assertion that with the assistance of Smartmatic software, Dominion had an ability to flip votes, she knew that was wrong. We have 160 paragraphs proving that Ms. Pirro, when those words came out of her mouth, knew that wasn't right. Second, we have 160 paragraphs in our complaint establishing that when Ms. Pirro said that, she knew that there was nothing in Smartmatic software that constituted a backdoor to flip votes. So when those words came out of her mouth, she was acting with actual malice when she did it. Judge, the next thing you brought up is that she said, hey, I'm just counting on some things that the lawyers filed. What? I have no clue what she relied upon. No one does. Not in the complaint, not in the answer, not in anything that...
What about Mr. Giuliani and Ms. Powell continuing to assert the fact that they had affidavits upon which they were relying?
What affidavits? What affidavits? I have not seen an affidavit. We've been dealing with this case for a long time. They bring up this whole argument that all they may have been doing is repeating some of the information that was in an affidavit or some of the information in a court proceeding. That's not been put in front of you. If I had that, if I was the defendant and I had this affidavit that Ms. Pirro was relying upon, or if I had a court proceeding that they were relying on and just parodying that, that would have been part of the record, they would have put it in front of you, and then they would have been able to do the comparison. That hasn't happened here.
what about the additional statements that Smartmatic denies these allegations?
There is no precedent at all that suggests the mere publication of a denial negates the defamatory impact of the rest of the publication. This whole monologue that she did...
But does it perhaps go to the issue that they are simply reporting? So they're reporting what Mr. Giuliani, Ms. Powell, et cetera, are stating, and then by the same token, they're reporting what Smartmatic is stating?
If you're focused on the November 21 broadcast in particular, not at all. She starts off the November 21 broadcast by making that defamatory statement about Smartmatic that she knows is defamatory. She goes on to say, Those types of allegations are supported by affidavits. Affidavits are super important. I'm a judge. If you say it in an affidavit, you're doing it under penalty of perjury, you gotta buy it. And then if she whispers under her breath, Smartmatic denies it, it's for a jury to decide whether
And
that
so
negates
she
it.
is
Absolutely
saying
doesn't. Sorry,
that
Judge.
there was an affidavit filed, and that these affidavits concerned certain allegations. She's not permitted to report that?
If what you do is simply what you just articulated, you then get into the realm of potentially the fair reporting privilege. That's where it would potentially come out to play.
Well, the
But
fair
we don't
reporting
have any.
privilege only applies to official proceedings.
Absolutely.
Did the public have the right to know that Donald Trump refused to concede the election and why?
Sure, I mean, people
Okay?
can report
And
that.
did the public have the right to know the reasons therefore, right or wrong?
So where the line has been drawn on this, and the Hustler Court actually gave us a very clear indication of where you draw a line on this. What you are articulating is there constitutional value in that information being disseminated? And there can be constitutional value to exactly what you've just articulated. But what Hustler says is, here's the catch. You don't get to do it if it's false, and you don't get to do it if you have the culpability standard, and that's the same thing that Hogan has telling us, right? So there is okay if you're going to repeat information that the President of the United States, and let's be honest here, there's no allegation here that President Trump ever made any statement about Smartmatic. We got to divorce that. Everybody's trying to make it sound like we're talking about President Trump's statements. That is a lie. That's not what we're talking about.
But what we're talking about
two
is a
private lawyers.
broad issue, possibly the most important public issue we have, about whether the bedrock of our democracy, that is a free and fair and integrity-filled election, whether that was tainted in some way, shape, or form. And now, various, as you mentioned, various news outlets are going to report this story in various ways. I think Mr. Clement said the same thing. And so it seems to me they clearly were permitted to report that, that there are allegations of fraud, that there are claims of fraud, and here are the sources of that. The question becomes really, did they become more than simply a reporter of the allegations, and did they instead themselves embrace the allegations, or did they themselves in turn assert those as facts? I think that's the key here, is that was something that was materially false or recklessly false held out as a fact.
Yep. Judge, I think you brought up a lot of good points with that, and I'll try to touch on each one as I'm understanding that point. First, I'm divorcing ourselves from a restraint of speech. Of course, people can publish what they want, but there's liability associated with what they're going to publish. Second is, once you are now talking
It's
about—
kind of cold comfort for a press defendant.
It is, but it's not cold comfort because the chilling effect that you're talking about right now, what Hustler and Hogan tells us is you don't worry about the chilling effect because the only time the press can get in trouble for doing that, the only time they get in trouble is if what they are reporting is false and if they acted with actual malice when they did it. And that is good enough protection according to the Hogan decision. That's good enough protection according to the Hustler decision. So you don't run into, I think, the concern that you're flagging right here. Actual malice is such a high standard that has to be overcome. Press has got plenty of protection under it, and they don't need any more. And all of this is circling back around to whether or not this court is going to adapt a brand new privilege, one that does not exist, in fact, has been refuted under New York law. There is no neutral reporting privilege under New York law. Doesn't exist for public, doesn't exist for private, doesn't exist under New York law. This is not the case where we should be creating new law. This isn't the case. Two big reasons for it. Number one is this court, the New York Court of Appeals, the US Supreme Court have all recognized there is no constitutional value to the intentional lie. They are in a category of speech that is considered valueless. So if it's an intentional lie, there's no constitutional value to it.
Particularly when it comes to officers of the court.
And that's what this court also said in the matter of Giuliani. And this court said in the Giuliani matter that defamatory and false information about elections in particular does grave harm to society. You don't protect this type of speech. You shouldn't make a new privilege for it.
And what duty, I think Judge Moulton had asked some questions earlier on this, what duty did the press defendants have to investigate the veracity of the claims that were being made on their program?
Their responsibility under Hogan, under Hustler, under Gertz is all the same. You have the duty not to act with actual malice. That's your duty. That's always the press's duty.
So that applies to, say, the Fox News subsidiary. What about the Fox Corporation? I see no allegations that they wholly dominated Fox News.
Thank
or
you.
that an employee participated. So why should you not be allowed to replete that claim?
Actually, thank you. That would be the last one I would want to touch on. We actually have 20 different paragraphs in our complaint detailing the extensive involvement of Fox Corporation in the participating in the publication, the dissemination of it. 20 different paragraphs where we lay this out. Fox Corporation, and these are all direct allegations about what Fox Corporation did, Fox Corporation agreed that they would disseminate the disinformation campaign. Fox Corporation agreed and participated in developing the defamatory themes of the reporting. Fox Corporation directed, authorized, and ratified the actions of Mr. Dabbs, Ms. Bartiromo, and Ms. Pirro. Those are 20 different paragraphs in our complaint where we are making a very specific allegation about Fox Corporation's participation in creating this defamatory material. Under New York law, anyone who participates in the procurement, composition, or publication of a defamatory statement is liable, and equally so under the law. Fox Corporation participated.
But not by virtue of its ownership.
That is not my theory. We are
Okay.
ships passing in the night.
Got you.
I'm not doing a piercing theory right now. Might do it down the road, but my complaint is on direct participation.
Okay, thank you, counsel.
Your Honors, just a few points in rebuttal. First, on Ms. Pirro, with respect to her role here, I mean, you know, she, as the presiding judge indicated, she made clear that she was talking about what the president lawyers were alleging, and she also did make clear that the voting companies, which at least at that point were sort of being treated together, denied the allegations. Now, the response we hear from the other side is, well, we alleged 160 paragraphs that Pirro knew that those allegations that were being made by Ms. Powell were not accurate. Even if all of that is true, that just shows the kind of the misfit here, because if some host actually knows that Ms. Powell is not telling the truth or has done a whole bunch of research, then of course she's going to start the interview by saying the president alleges that all of these 8 states had corrupt voting machines. And then they're going to ask the hard questions. And so the problem with the other side's analysis is it turns on, even when the reporter says, this is the newsworthy allegation, there's some independent obligation to do lots and lots of research. Now let's talk about Ms. Powell next, because it shows how irrational that responsibility and requirement would be in real time. Because
but you don't think in Ms. Pirro's case, just with respect to the statement that she made, that monologue that I read before, that she's basically recklessly accusing plaintiff of actually engaging in the vote rigging?
No, I don't think so at all. I think she's saying this is what the president lawyers allege, and then she has to explain what the allegations are. And then she also explains to her viewers what an affidavit is, and she's alluding to the fact that Powell, at her news conference just a couple of days before that, which is covered widely by the press, is talking about a specific affidavit she has. And she's actually explaining to her viewers that these are officers of the court who are telling you what they are going to have to prove. And so she's not saying this is true. She's saying this is what they say that they can prove. Now, Powell, in one time,
I'm a lawyer. I'm a former judge. I know what an affidavit is, and if somebody says something in an affidavit, that means it's true.
no, she doesn't say that means it's true. She
Well,
does
she
say
says in an affidavit, I think it was, I forgot the exact word, something to the effect, an affidavit is very important, something to that.
Sure.
Meaning that, again, leading one to believe that if you say something in an affidavit, then it's true.
that the affiant is swearing that it's true. But she is in that same paragraph, she's talking about how they are going to have to prove these things. And she is not saying, I'm reporting this as truth. She is saying, I have an interesting interview in the one show with Powell, and the other show it's just a monologue. She's saying this is interesting because they're going to have to be able to prove this. And they're going to have to do it in short order if they're going to change the election, which is what they're saying that they're going to do.
I want to ask you, Counselor, do we look at the monologue, the show that's a monologue, do we look at that differently, where you have the show that she's actually interviewing Powell?
Absolutely, but I mean, the monologue, if it's anything, is protected opinion. And I mean, and my friend, we could disagree about this, but I think, some of Bartiromo's shows are more in the nature of presenting the news. The news is the allegations. But the Dobbs show is very much an opinion show and a talk show. He's known for being kind of,
Well, but, yeah, in fairness to plaintiff, I mean, they go in detail about how Fox itself presents these anchors as, award-winning news individuals.
Sure, I'll take all of that, but Lou Dobbs if he's getting awards, it's in part because he's got a colorful show where he has opinions. Everybody who watches
Those
that
aren't the
show.
awards. It's not most colorful show of 2019 or.
Well, I would have to say that I mean,
Counsel, the
certainly,
bottom line is we're talking about a 30-11 motion again, right? So, we have to accept these allegations, right?
Okay, but you're also applying a heightened pleading standard under this court's Jimenez case, and so they have to allege this with clear and convincing evidence. If I could, just 2 quick points more in rebuttal.
Go ahead.
One is, on Powell, in real time, she's saying that their evidence is coming through a fire hose. She's making these very bold claims. So if the press really has to do this independent investigation before they can truthfully report that the president and his lawyers are making these allegations and they claim to have lots and lots of evidence, then the public isn't going to get the news in real time. That's just not realistic.
But if the news is false, or there's a question as to the quote-unquote news, why not just simply delay it for a short period of time?
Oh, I can't think of anything worse, Your Honor, than telling the press that in the context of a presidential election, they have to delay
I thought the election was over, no?
No, it's in the context of a disputed presidential election. The whole theory of why they...
Subsequent to the election.
Subsequent to the election.
Subsequent to the election, but before, the votes are going to be counted in the Electoral College. The whole theory of Giuliani and Powell at their news conferences, there's still time.
So the question is, at what point do you look at the fire hose that Ms. Powell keeps talking about? At what point do you have an obligation to say, well, wait a minute, show us one affidavit? Or show us one piece of evidence.
Well, and she claims to have at least one affidavit.
I know they keep claiming it, but you keep having them in the show for the 10th time when they keep saying, oh, no, we have the affidavit or we got the evidence. But and none shows up.
I mean, with respect, Your Honor, first of all, 9 of the 10 shows are before the president himself goes on an interview with Bartiromo and makes many of these same allegations. So these are still live allegations. It's not like, this time is passed over the story and they're still dredging it up. The president is continuing to dispute the election, and this is at least one of the bases that he's disputing the election on. So I don't think they waited too long, and in virtually every one of these interviews, they remind both Powell and Giuliani and their viewers, you're going to have to prove this, or this all doesn't matter. If you can't prove this, and prove this essentially in the next 3 weeks, none of this matters. So they are not presenting this for the fact of the matter asserted. Just the last thing. Just please understand how dangerous the proposition my friend on the other side is asking you to adopt. Because he says that all you have to do is report the allegation that the president is making. And if you haven't independently done your homework on the truth of the underlying allegation, you can't report it. That is just not a practice.
No, I don't think he's going that far, but,
I actually think
we'll test him on it.
Yeah, I actually think he does go that far. And there's just a fundamental misconnect. If you go back to Bush v. Gore, everybody on both sides was making allegations about everything from hanging chads to the Secretary of State of Florida misbehaving, violating the law. There were allegations on both sides of that. CNN was covering people. Every night you had shows where people were on there debating it. Some of them were kind of hangers-on of legal teams on both sides. They both couldn't have been saying the truth at the same time. Everybody covered it. It was the biggest story in the world. Nobody brought a defamation suit afterward. It's not the right path to go down with respect. Thank you.
Thank you, Mr. Clement. So how is this different than Bush v. Gore?
My client didn't get defamed in Bush v. Gore. So let me first make a correction here. I think my friend is misstating a little bit when he's discussing real time. I am unaware of any allegation indicating that any of these broadcasts are in real time where someone has to cut somebody off. That's not in the record before you, so that is not relevant to any consideration that we have. I also want to, again, correct the record. When Ms. Bartiromo interviewed President Trump afterwards, he made no statements whatsoever about Smartmatic. We gotta stop blending these things.
What about the Ms. Piro's monologue that it was pure opinion?
Absolutely not.
Mr. Dobbs is known for his opinions and not, I guess, reporting news.
Completely irrelevant. That's a great argument that one day may be in front of this court on summary judgment, may be in front of a jury. The allegations in the complaint under 3211 are the same. I have extensive allegations in my complaint already on how these were positioned, not as opinion pieces, but as news pieces. I also have extensive allegations in the complaint demonstrating how they actually set up their coverage, including Ms. Piro, as the source that you should be trusting for factual information, as opposed to everything you're hearing from everybody else. The way that this was positioned by the defendants for these particular anchors is, we are the ones that you can rely upon for the factual information. What you hear outside of our mouths is garbage and should not be believed. That is how they actually created a gloss of factualness to what they're talking about. Don't know if factualness is a word.
Sir, did your pleading obligation under CPLR 3211G as in George, did that obligation include the obligation that's contained in Civil Rights Law 76-A2 to establish by clear and convincing evidence the knowing falsity or the reckless disregard of the truth?
Yeah, I don't think it does. There's a case that we cited to you indicating that you're putting too heightened of a standard on me if I have to plead up to the clear and convincing at this stage as opposed to something that I have to do down the road. But even if I had that obligation from a theoretical matter, I more than satisfied it with 167 paragraphs on actual malice, and I believe I've got about 80 to 100 paragraphs on establishing falsity. If that doesn't satisfy my burden, I don't think anything can. I would like to talk very quickly about Piro, because I don't want us to lose. I'm so sorry, Judge.
No,
I apologize. I want to follow up on Piro on one important thing is, I don't want us to forget about November 14th, her other show. On November 14th, she had Powell on her show. Our allegations with respect to that show are very important. We have alleged that prior to that show, Ms. Piro had agreed that she was going to participate in a disinformation campaign. We have alleged that prior to that show, Ms. Piro had conspired with Ms. Powell to spread disinformation. We have alleged that Ms. Piro, before that show, understood what Ms. Powell was going to say and also knew that what Ms. Powell was going to say was false. And we have demonstrated that in that show, she gave an endorsement to what Ms. Powell said during that show by saying, yes, there should be an investigation and the DOJ should get involved too. I bring those up because it's critically important to remember that as it relates to November 14th, Ms. Piro is on the hook for the defamatory publications and the defamatory statements that were made during that show by Ms. Powell. She satisfies the test under New York law for participating in the procurement, composition, and publication of the defamatory statement because she had schemed and orchestrated that with Ms. Powell. She's on the hook for that too. And during that broadcast, Ms. Powell made a defamatory statement against my client. There are two independent reasons why Ms. Piro needs to be back in this case. Her own words in the course of the November 21 broadcast, and then also her procurement, participation, and publication on the November 14th show as well. I don't think she should be out of this case.
Okay, now with respect, just some housekeeping. I got the letter that talks about the re-argument that took place and the fact that the trial court reinstated the 9th course of action against Mr. Giuliani, right?
Yes, sir.
But that still means that
you still have to decide of and concerning.
You still have the 4th, the 3rd, and the 5th.
The critical issues, in the court reinstated the the ninth cause of action, I actually think the court reversed itself on all of the product disparagement issues. The issue with Mr. Giuliani that is still in front of you is the argument on of and concerning, and that the publications were actually of and concerning all three of the Smartmatic entities in a very simple nutshell.
So the mootness only applies to the ninth cause of action,
I believe,
not the third and the fifth. That's what I just want to.
Your Honor, I don't recall. I could do.
Yeah, because the lower court dismissed the third and the fifth. It only reinstated the ninth.
I think the court reinstated all of the ones that. He's right. You're right.
I'm right. There you go.
I always trust Mr. Whipper. On the of and concerning, very quickly, it's very, very simple. All of Mr. Giuliani's statements were attacking Smartmatic, the brand and the name, and I have over 30 paragraphs in my complaint establishing that all three of these plaintiffs are closely affiliated with the brand Smartmatic. All are involved in the development of the technology for Smartmatic. All of them had people contact them because they believed the broadcasts were about them, and I have allegations establishing that everybody who heard those and knew the plaintiffs understood them to be about all three of the plaintiffs. That was just it was a fundamental mistake and error that the lower court made by taking away two of my plaintiffs.
Thank you. Thank you both. This got submitted. That's why. Basden versus Liberty Lines.
Good afternoon. May it please the court. My name is Michael Gunsberg. I represent the appellant, Annette Basden. And I want to say that in the appellate division stated in Wegman that the rules of evidence are the palladium of the judicial process. And in this case, the trial court completely ignored all the rules of evidence and permitted highly prejudicial, inadmissible hearsay to be offered into evidence.
So this is the entire no-fault file, right? You're talking about what was contained in the no-fault file?
Yes, I'm talking about what's contained in the no-fault file, and I'm also talking about the MRI reports. And I'd like to actually address...
Well, let's keep them separate. Let's first deal with the pathology and surgical reports that were contained in the no-fault file.
Yes.
Why was that not allowed under the business exceptions?
Well, first of all, the Dr. Bott's operative report and Dr. Bott's pathology report was never authenticated by anyone. Okay, so I mean, just the basic evidentiary standards.
So they were not created by the no-fault insurer?
No, they were created by the hospital and created by Dr. Bott. And that was the underlying initial objection that was made to those records. When the no-fault file was produced, an objection was put on the record that none of the medical records that was contained in the no-fault file were actually authenticated by the medical facilities that were responsible for creating those documents and for maintaining them. And that's a basic evidentiary rule. And as the trial court, the primary role of a trial judge is the gatekeeper. And the judge has to initially evaluate whether the evidence meets the rules of evidence before you could offer it into evidence and permit a jury to hear it. And in this case, these documents were never authenticated. And most importantly, Dr. Bott never came to the courtroom to testify in the case. He never came in and got on the stand, raised his hand, and swore under oath that he performed this left shoulder surgery on Nanette Basden. And on top of that, Nat Basden denied she ever underwent the surgery. And even worse than that, Dr. Tyorkin, the certified orthopedic surgeon who came into court and testified as having performed a left shoulder surgery on Ms. Basden, told the jury that he saw no surgical scars on her arm, saw no evidence in the MRI reports that there was a prior surgery, and on top of that, that during
Counsel,
his
could
surgery—
Dr. Bott's records have come in because they were referred to by plaintiff's counsel first at trial?
They would
They opened the door, in other words.
No, no, no. The issue that was brought up was that the MRI report was referred to on the direct examination of Dr. Auerbach. And Dr. Bott's report and Dr. Bott's pathology report was never discussed by the plaintiff on direct, and it was never
What
brought
about
in.
while questioning Dr. Tworkin? Did they question Dr. Tworkin about Batt's path reports and operative reports?
Dr. Tyorkin was only asked if he saw any evidence of surgery being performed on Ms. Basden's left shoulder. And he indicated that there was no evidence from the MRI report. There was no evidence during his surgery. And by the way, Dr. Tyorkin also offered in as part of his
The Bat reports were marked for ID, and they just handed them to Dr. Tworkin?
Correct.
And said, what? Not that this refreshes your recollection, but just look at, I'm handing you these things. The jury doesn't know what they are.
Correct.
But do you have any knowledge that there was surgery? That was the nature of the question?
Do you know if there was ever surgery performed on Ms. Basden's left shoulder prior to your surgery? And the answer was emphatically no.
What's the point of handing these two reports to him then? You can ask that question without doing that, without handing the reports to Dr. Tyorkin.
Yes, but that's assuming he knew that there was an allegation made by the defendants in this case that Ms. Basden had undergone a previous surgery to Dr. Tyorkin's surgery. So it laid the foundation for him to understand outside the confines of the jury. The jury never saw that document. Right. They never heard about what was contained in that document. It was only given to the expert.
So therefore, you didn't open the door to the introduction of it.
The door was never open to the jury on that issue. And if I may also move on to the MRI reports. The MRI reports, I mean, look, Schozer and the Court of Appeals set the standard in the state of New York as to what the defendants were required to do here. Yeah. And the court specifically said, first of all, you have an issue. If you don't have the films, you have to at least make a diligent search for the films.
And so the Jones affidavit that says a diligent search was done, that's not in our record, right?
Not only is it in the record, it was never marked and submitted in evidence.
Never made a court exhibit or anything along those lines?
It was never done by the defendants. But more importantly, Mr. Jones never came to court. And Schozer specifically says that the person who is the custodian of the MRIs, the last custodian of the MRI reports, has to come to court and testify subject to cross-examination as to where the diligent search was made.
So an affidavit doesn't cut it?
No, the affidavit doesn't cut it, according to Schozer. But more importantly, and the Wegman court said this, that the most critical issue is reliability. Okay, and why is reliability so important? Because before you give a jury secondary evidence, you need to make sure that that evidence fairly and accurately reflects the original. And the original.
But there you had Dr. Lubin come in. Dr. Lubin came in and said, yeah, these are,
Sure, but the problem with Dr.
reports.
Lubin, and as the Court of Appeals said in Schozer, that he has to be able to recite and recant with specific details as to what's contained in the original. It says specifically, the proponent of that proof must establish that the witness is able to recount or recite from personal knowledge substantially and with reasonable accuracy all its contents. And Dr. Lubin was
So the
asked,
secondary evidence has to be authentic and reflect the contents of the original.
right, and Dr. Lubin was asked, Do you remember what's in the films? And he said, I have no recollection of the films whatsoever. So if he had no recollection of the films, he can't testify as to their content. If he can't testify to their content, there is no reliability for the court to rely on.
Isn't that always going to be the case? I mean, wouldn't it have been more strange if he'd said, yes, I remember these MRIs after so many years? I mean, isn't it always going to be the case that a doctor's not going to recall after some expiration of years? That...
I would be speculating as to what a doctor would testify in the stand, because I've tried so many cases, I can't really respond to that.
Thank you, Mr. Gunsberg.
Thank you.
May it please the court, your honors. My name is Carol Finocchio, and I'm here for the defendant's respondents. In my brief, I've tried to respond to everything that has been stated here, so I'll try to keep it brief right now and answer your questions if you have any. First of all, the no-fault records were admitted, according to the trial court, to show that plaintiff had treatment she denied. This trial was about the credibility of the witnesses.
But those files, the pathology report and the surgical report had no business being in your file. You can't vouch for
Your Honor,
documents.
Your Honor, okay, so a couple of things are being mixed up here. First of all, I don't know what you want to talk about first. Let's talk about the surgical report of Dr. Bott was never in evidence. What actually happened was plaintiff's counsel, apparently believing it was in evidence as part of the no-fault records, questioned Dr. Tyorkin about it in an attempt to show there was no evidence of a prior shoulder surgery. Dr. Tyorkin said, oh, you know, this is like the only record, and without any other records, this wouldn't show there was a prior surgery. So on cross-examination, the trial court allowed us to put into evidence the pathology report showing that fragments had been removed from the shoulder in the prior surgery. And Dr. Tyorkin was able to testify that, oh, it would be unlikely that those fragments would be removed if the shoulder surgery had not occurred. Now, I would submit, Your Honors, that any testimony about this is harmless error, because ultimately plaintiff's counsel admitted that there was no question she had the prior surgery. Initially, she took the position that she never...
No question she had I thought she continued to deny that she had the prior surgery.
No, Your Honor, I think it's page 937. I could be getting my number wrong, but she took the position at the outset that she didn't have the prior surgery, and there was a lot of back and forth during the trial about that. But ultimately, the plaintiff changed the position, saying, no, it has to do with the authenticity of the records. And our brief addresses this.
That doesn't mean that she conceded that she had the prior surgery.
Your Honor, she testified that she denied the prior surgery, but then she also testified that if there was records of the prior surgery, it may... she testified that if there was records of prior treatment, she couldn't say whether it was yes or no. There was a lot of inconsistencies in her testimony. But I do believe that in the record, the plaintiff's counsel at some point said, look, there's no doubt she had the prior surgery.
I didn't see that.
So I didn't see that. Were the surgical reports certified by either Dr. Bott
Your Honor,
or the hospital?
Dr. Bott's surgical report was not in evidence.
But it was in the, I thought it was in the no-fault file.
It's in the no-fault file. The confusion about this record that I had as an appellate lawyer is that it was supposed to go in subject to redaction, but in terms of it going in, like nobody indicated what was being redacted. So the records are all there, but it was not actually in evidence. Plaintiff's counsel is the one who brought up questioning about that report of Dr. Bott.
Did they get to the jury?
The report, no, the report of Dr. Bott never got to the jury, Your Honor. It did not get to the jury. What happened was plaintiff's counsel asked Dr. Tyorkin questions about it in an attempt to show that there was no evidence of a prior surgery, and we kept objecting. Defendant's trial counsel kept objecting. Wait a minute, you're asking him, he's a treating doctor, you're asking him about a report that is not in evidence. Now, the trial court said, look, if you want to put it in evidence, you got to get the doctor here. Nobody brought in the doctor. They didn't bring in Dr. Bott, and therefore Dr. Bott's report was never in evidence. But because the plaintiff's counsel elicited questions from Dr. Tyorkin about that report, the court allowed defense counsel to rebut the inference created that the surgery didn't happen because there were no reports about it. So that's
Sorry, I
when
don't understand. If the no-fault file as a whole is in evidence, then everything within that file is in evidence and could be shown to the jury.
Your Honor, the no-fault file was in evidence for the purpose of showing plaintiff had treatment that she denied. And there was...
So it was offered for the truth of the matter of the contents of the record.
Well, it was offered to impeach the plaintiff's credibility.
And it included Dr. Bach's...
It included, the no-fault file did include Dr. Bott's report, but the way the trial went in, it was my understanding, is that in order to get in these specific things, if Dr. Bott was going to testify, if someone was going to testify about the report, Dr. Bott had to come in. And as an example, let's talk about the MRI records of Dr. Lubin, the reports of Dr. Lubin. Dr. Lubin read MRIs in 2002 after a 2001 accident, but the films were unavailable, and the court was very clear. You can't offer these reports in evidence unless you have Dr. Lubin here and you show they were unavailable. So we met that burden. We had the affidavit from Jones, although it's not reproduced in the record, it was read into the record.
See, what I'm not understanding is that obviously the jury believed that there was some type of pre-existing injury, right? A pre-existing condition.
They did,
would
Your
seem
Honor.
to flow from a belief that the plaintiff had this prior surgery to her shoulder, which she stated she did not have.
That's right, Your Honor.
So,
That's correct.
I mean,
But there's
that's
other evidence.
the issue, isn't it?
That is the issue, but there was other evidence to support that, Your Honor. The Beth Israel records of Dr. Tyorkin's actual surgery that she admits that she had, if you read the Beth Israel records, it shows that the surgery was a revision, and the testimony was that a revision surgery means she had a prior surgery. So that was one thing. There's other evidence to support the notion that the surgery that he actually performed was a revision. It was not to do a reconstruction stemming from this accident. I see my time is up, Your Honor. Unless there are other questions, I will rest on my brief.
This is, okay. Thank you, counsel.
If I may just clarify a few facts. First of all, the plaintiff always did, throughout the entire case, deny that she had ever undergone left shoulder surgery before Dr. Tyorkin's surgery. And that fact remained contested by the plaintiff right up until today. Okay, so that has never changed. I have no idea what counsel is referring to when she says that the plaintiff conceded that she had left shoulder surgery. There's no such fact in the record.
I was under the impression that Dr. Bach's report was contained in a no-fault file, which was in evidence, and therefore was seen by the jury.
Dr. Bott's operative report and pathology report was contained in the no-fault file. The no-fault file was marked by the defendants and submitted to the jury. The jury saw the entire file and Dr. Bott's report and his pathology report. It was all marked in evidence. It was never redacted, and the defendants had it marked and submitted at the trial. I was a trial attorney, so I know that for
I mean,
a fact.
that's what I thought, but your adversary, said something different.
And as far as Dr. Tyorkin was concerned, defense brought up that there was a notation on one of his records that said, that it was a revision. They asked him about it. He said it wasn't a revision. That's the wrong word. It was a reconstruction. There was never, ever a prior surgery, and that's what he testified to, and he told the jury.
Okay.
Thank you.
Thank you. Thank you both. Jure versus Ulakaya.
May it please the court, my name is Richard Feldman. I'm appearing for the appellant, Aisher Dure. The lower court erred as a matter of law when it misinterpreted this court's prior decision on the appeal, which affirmed Justice Scarpulla's decision and order, which dismissed the original complaint and granted leave to replead the benefits.
Sir, in cutting to the chase here, there was an old commercial I remember seeing many years ago where some actor said, "Where's the beef?" Sir, in this case, based on the settlement agreement, where is the sale event? We understand that there are benefits. We understand that Judge Scarpula, on the previous case, Judge Scarpula allowed leave to replead the amended complaint for your client to establish certain benefits. We know what those benefits are. We know that the value of the defendant's shares increased from 60% to 80%. We know that certain fees were paid. We understand all that. So the bottom line for me, sir, is where was the sale of defendants' equity positions in Chobani that would entitle your client 10% of the $675 million loan by Hops to convert the warrants to preferred units?
That was the first appeal in which this court affirmed Judge Scarpula in dismissing that, saying that Dr. Jure was not entitled to 10% of the loan proceeds of $675 million. However, Judge Scarpula said you can go back and replead the benefits because the settlement agreement—
Only if those benefits are anchored to a sale event.
Correct. And so the settlement agreement defined what was a sale event. It didn't say a sale event is a sale or transfer. Instead, there's a whole paragraph in the settlement agreement which defines sale event as a transaction or a series of events and transactions which consummated becomes a sale event. The qualifier, series of events and transactions, means you don't look at the last stage. You look at anywhere along the continuum. And if there is a sale by Ulikaya, and again, this transaction was all orchestrated by the owner of Chobani Yogurt. He was the owner of 65%. He acquired 100% when he got the 35% equity from TPG. He sold 20% to TPG because Hulco 2 ceased to exist the minute that transaction occurred. It simply benefited him. He was—
But that's not what entitles your client to that 10%. Not that there was an economic benefit to a transaction to defend it, but as some of my colleagues have said, that there was a sale of equity.
And there was a sale of equity.
Okay.
It clearly was a sale of equity. It didn't have to be his equity. The settlement agreement said any sale of Chobani equity triggers it as a sale event, provided either alone or in a series of events or transactions.
Counsel, doesn't the consideration from the sale, I'm sorry to interrupt you, but doesn't the consideration from the sale or transfer have to go to either the defendant or a Ulikaya entity as defined in the settlement?
It doesn't say that. It says he has to receive the benefits. He received it by peeling off.
He received it for 19 minutes, right? I mean, it was only in that transfer entity for 19 minutes, right?
No,
Old
Judge,
Code
you're
2.
looking at the money. The money was under the first complaint. We're looking at all the other benefits that Justice Scarpula, who helped craft the settlement agreement, said we're entitled to replead those benefits. By saying we're entitled to replead those benefits, she's saying a sale event occurred. Why would she grant leave to replead? Why would this court affirm the granting of leave to replead, which is law of the case? If there was no sale event—
Sir, you can be granted leave to replead. That's fine. Nobody takes issue with your right to do that. The question is whether you've stated a claim under the settlement agreement, whether there was a sale event, whether you allowed these benefits to constitute the equivalent of a sale event. That's the issue.
Right. And that's why you were allowed to replead. You were allowed to replead so that you can provide the additional benefits that purportedly were received from the HOPA transaction, right?
Right. That's exactly right, Judge. The sale event occurred, or else it didn't matter if he received benefits. Judge Scarpula and not this panel, but a prior panel of this court said we could replead benefits. not whether or not a sale event occurred. Judge Scarpula said she stands shoulder to shoulder with Hamdi Ulukaya. If he benefits, she benefits. And she wanted to be able to compare whether the warrants, the 35% warrants, equated or were worth more than or provided a benefit to him than the 20% equity that he ended up, that was ultimately sold to who. And whether or not the option that he got for 10% more had a value under Black-Scholes. She wanted us to plead the benefits, but that presumed that a sale event had occurred. And the sale event occurred because in all the transactions that occurred on January 27th, that's when all those documents that are part of the record, the recapitalization, which allowed him to peel off 15%, the Third Amendment and the Fourth Amendment to the operating agreement of Chobani, which granted him loans and other benefits and granted him preferential treatment on the option, whether those, they were all exchanged on June 27th.
Sir, did Mr. Ulukaya actually act on those options? Those were
Yes.
potential futures.
Those options were given under the warrant purchase agreement to Ulukaya, to the founder. It was given to Ulukaya Holdings, his wholly owned entity, and Holdco. Not Holdco 2, which didn't exist.
But he didn't,
got
I
those
think,
options,
what
he
Judge-
exercised those options.
Counsel, I think what Judge Shulman was saying, he hasn't exercised those options yet, correct? At least not on the record.
Oh, sure he exercised it. He exercised the options as part of that transaction.
He cashed out the,
TPG got the $675 million. They conveyed in a bill of sale that equity to Holdings and Holdco 2. That's what happened. So he got the 35%. At that moment in time, he owned 100%. He then had Holdco 2 convey 20% as his designee.
Is Holdco 2 a Ulukaya entity? As
No,
defined
this
in
court,
the settlement agreement?
the settlement agreement provided that any entity that existed, Holdings and Holdco, or any subsequently created entity that held his interest would be a Ulukaya entity. This court held that for purposes of the $675 million loan, which it believed to be like a phantom because it didn't end up in his pocket, Holdco 2 was not a Ulukaya entity. However, it was the vehicle upon which he benefited. He stuffed his pockets with 15% of the equity, with 10% option with an option to buy 10% more to make his interest 90% of Chobani, as well as millions of dollars in legal fees that they paid on his account for these benefits, as well as investment banking fees of $10 or $15 million, which were for the sale of his interest and the increase of his interest in Chobani and getting rid of TPG.
Okay.
That's what happened
Thank you,
along the
counsel.
continuum of events.
Thank you, counsel.
Good afternoon. May it please the court. Brian Asher from Gibson Dunn for the respondent, Hamdi Ulukaya. Justice Shulman, you had it exactly right when you asked where is the sale of a Ulukaya entity's equity in this transaction. Where's the beef? I couldn't have said it better myself. Mr. Feldman, the plaintiff has still alleged in the amended complaint that there was a sale of Ulukaya's equity in this transaction. This court held definitively that the sale of equity in this transaction, that for a brief moment in time passed through Holdco 2, which was an entity owned by Mr. Ulukaya. When that equity passed through Holdco 2, it was not a sale by a Ulukaya entity under the settlement agreement. It was the exact same transaction documents that this court looked at back then. It's the same transaction documents that were before Justice Ostrager when he addressed the second amended complaint, which came after this court's ruling. So the plaintiff had a chance after this court's ruling to plead again and try to come up with an explanation to answer that question, which we've had the whole time as well. Where is the sale of Mr. Ulukaya's equity? There was none. And the reason that's critical is because the settlement agreement here, which is clear and unambiguous, effectuates in plain terms the party's intent, which was when Mr. Ulukaya monetizes his Chobani equity, the plaintiff gets a payment. Every time that's happened, he has done so. It will continue to happen into the future. But it didn't happen in this Hoop transaction in 2018. One third party, Hoop, came in to buy out the minority equity interest in Chobani held by another minority owner, TPG. Mr. Ulukaya created this entity, Holdco 2. It's established by the documentary evidence to facilitate that transaction, just to pass through, the same way that the money that Justice Garpool looked at, that this panel looked at, passed through Holdco on its way from Hoop to TPG. The equity passed through on its way from TPG to Hoop. It passed through and Holdco was dissolved. But what was sold, that equity, that briefly passed through Holdco 2, was not the equity of a Ulukaya entity under the settlement agreement. And the Second Amendment complaint alleges the exact same thing that the original complaint alleged with respect to that sale event. It says, when Holdco 2 sold that equity, it was the sale by a Ulukaya entity. It says Ulukaya and Holdco 2 were one and the same. He controlled it, he owned it, so it's all his. Those allegations have not changed at all. And that is precisely what this.
What about Chobani's paying the legal and financial advisory fees? Is that a benefit? Is that a realization of some benefit that would be cognizable under the settlement agreement?
No, it's not, Your Honor. And Justice Ostrager rejected that claim precisely for the reason that the agreements with those advisors that participated in the transaction, that advised on the transaction, were assigned to Chobani. Chobani got the benefits of the services of those advisors, and it took with it the obligation to pay those advisors. So when Chobani pays advisors in a transaction that is done, that Chobani participates in, and it gets the benefit of those services and it pays those services, that is not in any way.
That's not a distribution.
Exactly right. It's not a distribution. It's not proceeds in any way. And just to put this in perspective, the only thing that's changed in the Second Amendment complaint is what were the supposed proceeds that Mr. Ulukaya received. The core of what was the sale event, the sale of Chobani equity that passed through Holdco, hasn't changed at all. And what they've said now, the first time they said, well, the money that passed through, those were the proceeds, we get 10% of that. Justice Garpula and this court said no, because there was no sale by a Ulukaya entity. They have continued with that defective foundation, and now they have just, all they've changed is what they say were the proceeds. They say, well, the benefits here, the proceeds were these intangible benefits. He gets more control over the board. He gets access to better distribution in the future, and they say they should get 10% of that. But that's all, those are all things, again, they don't stem from a sale of equity by a Ulukaya entity. That ends the inquiry. But just to put it in perspective, if and when, because of he's in this more beneficial situation, as plaintiff alleges, and he can turn his equity into more money faster in the future, plaintiff will get the benefit. For example, plaintiff says he gets better access to distributions now. Plaintiff somehow wants 10% of the right today to get access to better distributions in the future. In actuality, when and if he gets those distributions, he will pay 10% to the plaintiff. This just happened last week. He received a distribution from the company. We provided notice to plaintiff, as we're obligated to under the settlement agreement, that says a distribution was made, you'll be getting 10%, we're wiring it to you on this date. So this relationship will go forward. He will continue to make good on his obligations and pay 10% when and only when he sells or monetizes his equity, the equity of a Ulukaya entity. Now, very briefly, I think I've addressed most of the ways that the Second Amendment complaint didn't change at all. The plaintiff did attempt to lob in a few additional sale events in the Second Amendment complaint. Justice Ostrager considered those and rejected them as well because they just make no sense. Plaintiff says somewhere along the way in the Hoop transaction, when an entity that he owns called Holdco 1 assigned the right to Holdco 2 to acquire the warrants and turn them into the preferred units for Hoop, just to function as that intermediary that we've been talking about. He says, well, that was a sale event. Well, of course, that makes no sense because there's no sale or transfer for value there. There's no sale of Mr. Ulukaya's equity, and it flies in the face of plaintiff's main argument, which is that Mr. Ulukaya, Holdco 1, Holdco 2, they're all one and the same. That's the core of the original complaint. It's the core of the Second Amendment complaint. If they are, then transferring just the right to participate as the intermediary here cannot be a sale event. The second allegedly new sale event that plaintiff claims happened in 2015 when Mr. Ulukaya moved his equity from an entity called FHU Holdings to this entity called FHU Holdco. That took place before the settlement agreement was even signed. It's in the record. There's an org chart attached to the settlement agreement that reflects that's how the equity is already held. It can't possibly, therefore, trigger a payment under the settlement agreement, and it obviously taking place 3 years before the Hoop transaction. has nothing to do with it. And finally, I see my time is running out. The fundamental argument in appellant's brief is that Justice Scarpula, when she, at the trial court, dismissed the original complaint, somehow ruled on the merits and blessed the merits of an amended complaint that wasn't yet before her. And then the next allegation is this court affirmed that phantom holding sub silentio. That is, of course, impossible. A judge cannot bless and rule and prejudge an amended complaint that's not yet before the court. Justice Scarpula made absolutely clear she wasn't doing so, and appellant had no response in the reply brief to that. Thank you.
Thank you, counsel.
Respondents specifically argued to this court and Judge Scarpula that no sale event had occurred. On page 813 of the record and page 829 of the record, those very same arguments were presented. This court, by granting but Judge Scarpula and this court, by granting leave to replead and affirming that grant, disavowed that or rejected that concept that no sale event had occurred.
Counsel, we did not do that. We just said, we said that Judge Scarpula contemplated there's going to be a Second Amendment complaint. That's all. We just mentioned it in passing. I was on that panel.
However,
we didn't bless, the theory of liability, the theory of recovery. We just said, okay, take a shot.
Right. Give us the additional benefits that you claim.
The benefits, right. However, the benefits, again, all the transactions occurred on June 27th. They were all in one room, or an escrow agent had all the documents. The $675 million came in, and someone pressed a button, sending out all the agreements countersigned. It all happened at the same time. The sale event by Holdco 2 at the end of the line was simply the trigger event. The benefits that we described, the 15% that he peeled off, which has a value of $350 million, the 10% option that he has, were all derived from all those series of events and transactions which the settlement agreement defined as the consummation of a sale event. It didn't have to be the final step. It could be all of, or any of those.
Well, just with respect to the options, they will still have to be consideration actually received within the meaning of the settlement agreement, right?
Correct. And we say that the benefit that was received came not from the $675 million that went directly to TPG through a bank account that was not just Holdco 2's. It was Holdco 2 and Holdings, because Holdco 2 didn't own all those warrants. It passed through their joint bank account, but we are saying that his benefits included the 15% that he got in this series of transactions and events, and that by interpreting it out of the agreement, the lower court misinterpreted and misapplied the law in terms of construction of unambiguous agreements. Otherwise, there would not have been that reference to series of events and transactions. It would have been simply a sale triggers it.
Okay, thank you, counsel.
Thank you.
Thank you both. People versus Pimentel. I gave her time. She said she had an asthma attack and she's going to get fired if I don't give it,
Good afternoon, Your Honors. May it please the Court. My name is Sarah Chaudhry, and I'm counsel for Appellant Angel Pimentel, who is before this Court seeking a reduction in his post-release supervision term from the maximum of 5 years to the minimum of 2.5 years. First, we submit that because Mr. Pimentel was a first felony offender, that augurs in favor of a reduction of his post-release supervision term. Second, this offense was committed when Mr. Pimentel was at the age of 23. Research indicates...
Well, that and another 10 times in which he received youthful offender, right?
Well, Your Honor, respectfully, youthful offender adjudications should not be considered because, first of all, they're not convictions. Second of all, the fact that they're youthful offender adjudications and are...
But it's not like they didn't happen, right? So I agree this was his first felony conviction, but he did receive youthful offender 10 different times before that, at least one for robbery.
That is correct, but part of the reason why that should not be considered by this court is his youth in and of itself indicated.
Was he recently arrested for robbery?
Your Honor, that is a.
I mean, he can't seem to get away from robbing people and pistol whipping them.
I understand that he was allegedly rearrested. However, an arrest is not tantamount to a conviction. That's an underlying principle that we all labor under, correct? So,
Well, he wasn't allegedly rearrested. He was rearrested. The allegations that it was a robbery, right?
right, he was rearrested, but he is
Right,
not.
but you said allegedly rearrested.
I misspoke. You're
I know.
correct.
So, but what I'm trying to figure out now, you want a reduction in the post-release supervision
Correct.
based upon what? That he's not a candidate for post-release supervision?
Well, a few points. So one, I've already mentioned the fact that this was his first felony offense. Second, the age at which he committed this offense is an age that is associated with immaturity, impulsivity.
Right.
He is now nearing the age of 30. Perhaps my strongest argument, however, in favor of a reduction in the post-release supervision term is the Less is More Act.
Right. And
Often the
so that was my point, because I thought that's where you were going, because less is more. He doesn't need post-release supervision, but then he's got the new arrest. So what I'm trying to figure out now is, doesn't the fact that he has a new arrest kind of go against your argument that post-release supervision is not necessary?
No, that's not correct, Your Honor. That would only be true if you were convicted of this offense. Now, for those individuals who are arrested and are then later, it's determined that they did not commit the offense, they are credited with the time that they would have been had they been out in the community and not reoffending. So even with less is more, which, as you all know, the principles underlying that act are that lengthy terms of post-release supervision, such as Mr. Pimenthal's, are actually counterproductive. So even if we were to apply that act, Mr. Pimenthal would be left with 2.5 years, which I know that's what I'm asking your honors to give him. However, 2.5 years is still 6 months to a year more than what's deemed optimal in terms of allowing people and helping them to not reoffend.
But it might be academic, because he may be incarcerated on this new robbery, right?
It may be academic, but as of right now,
it could well be academic. It just seems to me that he needs the post-release supervision, and that he may need more post-release supervision since he continues to, as my colleague stated, as the PJ stated, rob and pistol whip people.
Your Honor, if I could just respond to that. I know my time is up, but
Go ahead.
I wanted to respond to that. I feel strongly that we should not look at Mr. Pimenthal as just this incorrigible reoffender, when currently before this court, what we have is an arrest and not a conviction. So while this may ultimately end up being academic, as we sit here today, looking at the record that is before this court, and even if we take into consideration this post-record alleged conduct, I think we need
so
to adhere
we look
to.
at him and we don't consider the YO adjudications. We don't look at the new arrest. We only look at this incident. This incident is a gunpoint robbery? Yeah, a gunpoint robbery of a stranger on the street, where Mr. Pimentel demanded money from the individual, and I guess when the individual
Took his phone.
And took his phone, but also struck the individual into the head and to the face with a firearm, and again took his phone. So just looking at only at this incident, he's sentenced to 3.5 years incarceration with 5 years post-release supervision.
And 3.5 being the minimum. He could have gotten up to 25 years after trial.
And the 5 years post-release supervision.
That's correct, Your Honors, and I do not in any way want to indicate that I'm diminishing the harm suffered by the complainant. But here we are today, and we're trying to determine what is the best way to help both Mr. Pimenthal and society.
I agree. I mean, at what point does he mature? He's 30 years old, and he's still being accused of robbing somebody. Let's not take it into account. At what point do we need to protect the rest of society from him? When is he going to mature enough? Because, I mean, the studies that you referenced, an adolescent, let's not take into account the YOs he got. But like, you know, at what point do we protect people from him? Or
Your-
from his pistol whipping?
Your Honor, I agree with you. We have to, you're right, we have to protect the community, and we also have an obligation to those of us who may be having a hard time, right? But again, to take into consideration this arrest as proof of the fact that he's not matured,
And I said we weren't going to do that. But you're talking about, we're not even talking about incarceration because he completed the sentence. He's only in because there was a violation of probation and this new arrest. You're talking about supervision. And so why should he not be subject to supervision to ensure that he leads a law-abiding life, that he gets the services that he should receive so that he will be able to mature at 30-something years of age?
right, so he will still be getting the 2.5 years of post-release supervision. If I could just, give an example, right? Think about a student that is maybe not the best student and gets into trouble. If you have harsh penalties against that student, and I'm gonna just, if you indulge me, I'm gonna analogize that to the 5-year PRS, right? Often we'll see that there's no change, there's no shift there. Less is more is animated by the principles that a shorter term is actually not just a you get out of jail free. You have the term and you have the time that you need to actually get better, and society is also protected, rather than putting you within a situation that might be creating the very harms that it's designed to prevent. So I'm not asking, Your Honors, to get rid of all of his PRS. I'm saying if we look at his offense, if we look at the research that talks about the impulsivity, immaturity of youth, if we look at his record, and if we look at less is more, and those principles, we're not doing him a favor by cutting down the PRS. I think we're taking a look at it and saying what's fair and what's going to help him and us.
Okay, thank you, Counsel.
Thank you.
Good afternoon, Your Honors. May it please the Court, ADA Stephanie Nelson on behalf of the people. As Honorable Weber stated, there are a totality of circumstances that the court considers. Here, this court has broad plenary powers to modify sentencing if that sentencing is unduly harsh or if the sentencing is just extremely excessive. The lower court did a good job at looking at all of the circumstances, and one thing that was not presented to this court is one of the 10 YO adjudications resulted in the probation sentence. That probation sentence ended in October of 2022. So again, I'm so sorry. Let me not misspeak. As part of the record, if you look at page 11, the probation sentence started on October 19th, 2012. And at the time of this offense, the robbery was during his probation sentence. So he had a 5-year probation sentence. And during that probation sentence, he committed robbery in the first degree. He was indicted for many more, but the people gave him a plea of robbery in the second degree.
So this was a bargain for plea, is that correct?
Yes, it was a plea, and the
It was
people.
a plea bargain.
Yes.
And is there any issue with the waiver?
No, there is no issue with the waiver. If you turn to the plea minutes, page 9 through page 10, Judge Sherry Michaels does a good job at expressing to the defendant and explaining to the defendant what an appeal waiver is. Page 10, she asks the defendant, does he understand? She asks the defendant, did he go over it with counsel? And then she said, it's a requirement. It is. It's a requirement. It's part of the plea. He pled to robbery in the second degree. And Judge Michaels also said on page 12, you should not be reoffending, that this plea would be moot. What he did was public record, presented before this court, presented before defense. He reoffended on post-release supervision. So he offended while he was on probation from his YO adjudication for robbery in the third degree, violated probation. We allowed him to collectively add that sentence as a consecutive sentence. that it won't run any other, beyond what he got with the 3 years sentencing for the second-degree
And
robbery.
that itself was the minimum.
And that was the minimum.
Okay.
Okay.
Thank you, Counsel.
Thank you, Your Honors.
And as previous PJ used to say, you got a tough road to hoe.
Sorry, say again? Okay, sorry.
Doesn't matter.
All right. Okay, so first of all, in terms of reoffending with respect to the plea conditions, that's what the court was saying to Mr. Pimenthal with respect to the time between plea and sentence. Secondly, in terms of his YO adjudication, in some ways that just proves the point, right? So he has this probationary sentence that's 5 years. It's a longer term than was necessary, and though it may seem counterproductive, I think that term of probation.
Proves what point?
It proves the point.
So your point is that he should not be subject to post-release supervision. Is that?
No, my point is that lengthy terms of post-release supervision have been shown to create the very ills that they're designed to prevent. And that is why the legislature.
So your position is that we should reduce the post-release supervision, and so now he would almost have completed the post-release supervision, and then he just goes on his merry way without any supervision whatsoever?
He still has a term of supervision. It's 2.5 years. So it's not that he's getting off scot-free.
But he wasn't even able to complete the probationary period, right?
Well, Your Honor, with respect to the probationary period.
I mean, I'm just thinking at some point in time, there has to be something that we can do to assist him. And I understand you're talking about his youth, but you would think that during those 10 their adjudications and then the 2 robberies, that at some point in time you got to start thinking youth is not the answer. It's like because you're 79 years old and you're terminated, that doesn't mean you're terminated because you're 79 years of age, right? And so because you're committing 10 offenses, and then 2 robberies, it's not you're doing so because you're youth.
Well, of course, I think that in terms of does he bear personal responsibility here? Absolutely. But can we diminish the fact that those youthful offender adjudications, which once again are not convictions, as well as the instant offense, occurred at a time where research indicates that you do have the impulsivity, immaturity.
20-something years of age. He was 20-something years of age, right?
He was 23. And
He's 23.
a lot of
He's now 30?
He's close to 30. But again, I want to say again, I think it's impermissible and improper to take into consideration the arrest that's not before the record. We're not judge and jury here, right? Sorry, you all are judges, but we're not in terms of that offense, right?
We don't do that anymore.
And if I could just, I know my time's up, but I just wanted to reply really quickly to the waiver argument, which is that the waiver here is invalid for 2 reasons. I'll just get to the second reason, which I think is, what counsel had pointed to. The lower court described waiver in a manner that's contrary to established law. So the lower court's colloquy indicated that by waiving appeal, Mr. Pimenthal would not have recourse to a higher level court to challenge any errors that the lower court made, and that he would not have the ability to have appellate counsel should he be unable to afford it. And for that reason, given that the way that the court described the appeal and then described the waiver, I do not think that we could sit here and look at this waiver and say that this was actually voluntary.
Thank you, counsel.
Thank you. Thank you.
You got it. Gibson done?
May it please the court. If a defendant wants to vacate a judgment that has been in place for many months, what is the nature of his burden and how does he carry it? Here, the judgment debtor produced written statements from 2 men who, for whatever reason, refused or failed to make themselves available for cross-examination. And the judgment debtor produced nothing from the attorney who represented him in court for 3 years, answered on his behalf, waived defenses to personal jurisdiction and service.
So it's not your burden to show actual authority, is what you're saying?
It is not my burden to do anything, Judge. There is a...
I'm just asking about actual authority.
I'm sorry, Judge, I couldn't hear you.
Okay, Counsel Santa Maria, the question is, did he have actual authority to act on behalf of Junior?
Yes.
Okay, so whose burden, I mean, don't you have to show that he did have authority? I mean, what indicia of actual authority is there?
Respectfully, Judge, I don't. The case law is that when an attorney appears for a client, that is presumptive evidence of his authority. And it will be 13 months after the judgment has been entered and after the defendant here had notice of the judgment, it is his burden to show that Mr. Santa Maria had no authority. What we have in the record is an engagement letter signed by Joseph, his brother, on behalf of all 5 of the defendants. We have a Joseph affidavit in the lower court in which Joseph says that he's making the affidavit on behalf of all 5 of the defendants. We have a motion by Mr. Santa Maria for leave to withdraw as counsel for the defendants, which motion is denied by the IAS court. There is simply nothing in the record that he didn't have authority other than this defendant's say-so after 13 months of doing nothing, after he knew that there was a judgment that was entered because this attorney showed up for him.
But the time is irrelevant. If the basis for the vacatur motion is a want of personal jurisdiction, there is no time period on that motion.
That is correct, Judge, but if the issue is whether or not this attorney had authority to, there's no dispute, Judge, that this attorney signed court pleadings purporting to waive personal jurisdiction and service. If the issue is whether this attorney had authority to do that, at some point, I believe the case law indicates that the client, Mr. Diana, has ratified the conduct of the attorney by months and months of silence in the face of full knowledge of the judgment and full knowledge of how the judgment came about. And there's no dispute in this record that he did have that knowledge and that he was silent. He consulted with attorneys. The attorneys began preparing the papers. There's some discussion in Justice Cohen's opinion about COVID, which, you know, at times can be a catch-all clause for whatever anybody wants to excuse.
Well, he talks about the extraordinary circumstances of COVID, the fact that the court proceedings were suspended in all civil matters, and so therefore he found that Junior's delay was excused.
Right, which is a different subject from the issue of whether the defendant here, confirmed the authority by his silence. There's a separate issue in this case about whether the motion was timely. But on the issue of whether the motion was timely, Judge, I'll ask that you focus on the fact that the record shows that Mr. Diana's counsel began preparing the motion 9 months before the suspension of proceedings that Your Honors referred to.
Thank you, Counsel.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court. My name is Michael Lienoff from Lebanon Kaufman, attorney for Elio Dana, Jr. What we have here is a situation. It's a very basic 50-15 and 317 motion to vacate a judgment entered against a gentleman who had no knowledge that the judgment was entered against him. From the totality of the record, it seems that Mr. Dana, Jr. had only obtained knowledge in July of 2019.
He says, there's someplace in the record where he says Mr. Santa Maria did not have authority on my behalf.
He didn't have authority to, he gave no authority to Mr. Santa Maria. He had no knowledge of anything that happened in this case before July of 2019.
So Mr. Santa Marina, I mean, we've had this issue show up in a variety of ways. Like, for example, the execution of a settlement agreement in open court by counsel and how we have to presume that there is apparent authority to execute that agreement. Here you have someone who basically appears in behalf of an individual and does what? Interposes papers in the court.
That is, I believe, what happened, yes.
An officer of the court. So why isn't that presumed to be authority to appear? I mean, attorneys are not accustomed to appearing for free on their own without being asked to appear by the person they purport to represent, right?
That's true, and we believe, although I've had very little contact with Mr. Santamarina, but I believe that's exactly what happened. If you read the email from Joseph Dana to Elio, his brother, in July of 2019, Joseph is introducing this case for the very first time to Elio. Elio had written to him and said, "Dear Joseph, what is happening here? Why do I have this judgment against me?" And Joseph is reassuring him, "Don't worry about it. This has nothing to do with you. I got an attorney on your behalf. He entered. We'll get you somebody. We'll take care of this for you." He's introducing this case for the very first time to Elio Jr.
Okay.
And the case law says the predominant case in this matter is Skyline Agency versus Ambrose Capitelli. Ancient cases which uphold the validity of a judgment entered against an unserved party for whom an unauthorized appearance was made by a solvent attorney were premised upon the party's right to sue the attorney. These cases have no present-day validity. So Skyline is abrogating the entire history of cases that came before it in which courts were upholding that it became the burden of the served party, the unserved party, to chase after the attorney. Now it's not that party's burden. We simply presume that the attorney who had no authority and who nobody can prove had any authority, that appearance is invalid.
Okay. Thank you, counsel.
Thank you.
Your Honors, I know I only have 1 minute. One, there should have been an evidentiary hearing at which Mr. Santamarina testified. There's never been any evidence submitted from Mr. Santamarina. Two, I'd ask the court to look at page 598 of the record, which is Mr. Santamarina's engagement letter, which Joseph signs, quote, on behalf of Elio Jr. and the other defendants. Thank you.
Okay, thank you. Sinsheimer.
May it please the court, Bruce Wiener for the appellants. This court should reverse the single sentence order below that denied the Yellowstone injunction to the appellants. The order was...
This is not a commercial lease,
It's
right?
not a commercial lease, but the court, the only case that the court cited in the one-sentence order was a case from this court, which dealt with a proprietary lease in a co-op, just as we have here.
But
The
even
Stoltz
that
case.
But even that case talks about RPAPL 753-4, which provides the necessary remedy in a residential case. And it will be upon you to show that somehow 753 is inadequate.
Yes,
in protecting you, right?
It's definitely inadequate, even with the 30 days, when you have a landlord who is preventing you from curing. The cure
How is he
not
preventing you from curing?
The cure is not vacating. That's turning Yellowstone.
Have you tried to buy the shares?
No. Dr. Sinsheimer is the executor of her mother's estate. They lived in the apartment, she and her children, with her mother for 20 years. Suddenly, after the mother dies, they claim an illegal sublet, which is completely ridiculous to claim an illegal sublet when you have relatives. There's no presumption.
I'm sorry, Mr. Wiener, what was the daughter name on the shares?
No, the daughter's,
Okay.
no, she paid the maintenance.
Slow down. We have the daughter and the two children living with the mother who was the shareholder.
Correct.
And the will ultimately allowed transfer to the daughter.
Yes.
And a simple matter would have been for the daughter to do some paperwork, pay $60 per share for whatever number of those shares, and then she would be a shareholder and step in the shoes of the mother as the proprietary lessee, correct?
No, because the co-op, if you look at the notice to cure, starting on the record at page 60, they're relying on two proprietary leases. The 1996 lease, which another court in a prior case found was the controlling lease, and the co-op never appealed that determination. They put in the notice to cure 2 different leases that they're claiming we violate, and they want to terminate 2 different proprietary leases, one from 1996 and one from 2014.
But
Mr. Shulman,
either one gives you the...
No. The 1996 lease says they cannot unreasonably refuse to consent to a transfer. The 2014 lease says they can refuse. At the same time, they're trying to extort $100,000 of legal fees. They said, we won't allow you to transfer, we won't allow you to sell unless you pay us $100,000 in legal fees where no court has ever determined that they were the prevailing party. In fact, they're seeking fees from this very case that's still before the court below. And from 2 other cases where they lost. And they're still seeking to say, you have to pay us $100,000. And the 2014 lease, unlike what Your Honor cited from the 1996 lease, it's not $60 a share. It's 3% flip tax, even on a transfer to Dr. Sinsheimer, the daughter. Okay. And that would be 3 times what the transfer fee would be.
Quick question. I didn't really find it. If you can tell me where I could find it. Was the 2014 proprietary lease actually signed by the decedent mother?
No. Never signed. Never
so if the
never
2014 proprietary lease, the putative lease was never signed, then what's the point? Then you don't have any exposure for any violation, you know.
Well, why should I have to litigate in the housing court when I have all my causes of action in the Supreme Court concerning the legal fees, the flip tax? There's other requirements that the 2014 lease impose on us that the 1996 lease did not, and they refused to recognize something that they didn't appeal. They lost that case. The judge found, Judge Halm found, that the 1996 lease was controlling. They turn around, they fabricate an illegal sublet, and they put 2 different leases claiming a violation and seeking to terminate 2 different leases. Justice Shulman, I'm sure in your career you've never seen a notice to cure that relied on 2 different leases and sought to terminate 2 different leases. Just doesn't happen.
Thank you, counsel.
Good afternoon, Your Honors. Jeffrey Metz.
Yeah. Do you want to address yourself to the 96 lease governs, correct?
Absolutely does. And Your Honor,
you're not entitled to $100,000 worth of legal fees on a case that you were not the prevailing party, are you?
We're not, Judge. He's making,
I just want the answers to that. Am I correct in that?
in terms of
He said you extorting them
What,
100
Judge?
grand based on cases that you lost.
Judge, there is, from what I understand, there are legal fees that are part of the charge, but that's not the issue that's before you right now, Your Honor. What's before you right now, as you pointed out initially, is whether a Yellowstone was properly granted. Everything that he's telling you, most of it hoards the record, by the way, everything that he's telling you can be raised in a summary proceeding, and if they lose, they have the ability to cure. Now, I don't want to...
Why can't we just deal with it in Supreme Court? I mean, housing court is a court of limited jurisdiction. He sort of locks them in a little bit.
Not
Why
really.
in Supreme Court?
Well, Judge, when I was researching this case, it's going back to the legal memory lane for me. Post says, civil court, it's the court, limited jurisdiction. If you can determine it there, you determine it there. I went to see, are there more recent cases on that? But there aren't, because that has been the law for the past 30 years. Now, let's just talk for a second about what they can do. First of all, the 2014 lease, that is an irrelevancy that was disposed of in the prior case. We're not relying on it. We're relying on the 96 lease. The 96 lease says that there's a $60 a share transfer fee. So what she can do, very simply, just end this right now, just request to assign, because the lease, the proprietary lease, gives them the right to do that. The will that she says she...
The 96 lease, which
96,
prevents you from
that's correct.
unreasonably refusing.
That's correct. And they said, well, they can't unreasonably refuse. We're financially responsible. Okay, fine. Make the request. Never made the request. The mother has been dead for 3 years. They have never made the request. Number two, have they ever sought to sell the apartment? The answer is no. What they're trying to do, and you see it in the papers, all they've been doing with this thing, Your Honor, is basically using the court to delay everything to time market conditions to sell the unit. That's what they're doing. Now, we can go ahead and let's just be pragmatic about this for a second. You affirm, because I think you should, you affirm we go to housing court. This takes a while. They can appeal it. They have plenty of time to remain in there. There's no reason for a Yellowstone. The rarest of rare occasions when Yellowstones are granted in a residential setting is when you can't cure within the 30 days. This is not a situation like we cite in our briefs where there's an illegal alteration and you're attempting to cure, but you can't get the DOB permits in time. They can cure right now. They can leave the apartment, which they say that they want to sell, that they intend to sell for the highest price, but they're not doing that. And the fact of the matter is, Judge, I don't want to hear about this subletting because that's just not, it's not, well, excuse me, I'm getting a little.
What's the substantial violation that they need to cure?
The substantial violation is Article 3A. It says.
Of the 96 lease.
Of the 96
proprietary
lease.
lease.
That is correct. You see, they want to have it both ways. They want to say that their family members under the 96 lease, okay, they were when the mother was alive, but they don't want to acknowledge the provision that says when the proprietary lessee ceases to be, you don't have the right to be there anymore. And if you want to go into the merits about this, Judge, it's very clear because it is actually one of my cases back from 1986. The executor cannot occupy in a residential capacity. That is clear. That is your court saying this. And also, Your Honor, the law also provides that if somebody is in there other than the lessee, the law presumes an illegal subletting or an assignment. And by the way, that is something that's over 100 years old. That's the Mann against Ferdinand Munch case. It was decided in 1919. So, I mean, we have a situation here where the system is being gamed a little bit to time the market. So it's not what a Yellowstone is for. The commercial can't terminate, they can't cure once it's terminated. They can cure. That's what Post is all about, that they can cure. So I would submit to you, Your Honors, that this order is a simple order. It should be affirmed. Thank you.
Okay, thank you. Okay. You got 1 minute.
Yes, Your Honors, I think it's my friend who wants to have it both ways. When they cite to the notice to cure in their brief, they eliminate, using ellipses, they eliminate any reference to the 2014 lease and only seek to rely on the 1996 lease. But if you look at
Well, you heard an open court admission that the 96 lease applies, and that's being adjudicated.
well, that wasn't the admission below, and certainly it's not the admission in the record on appeal.
You have it now, and you can cure. That's the point, right?
We can't without paying the attorney's fees. They've told us that. They won't even let brokers in. That's what they're doing. They won't allow restoration of the gas service in the apartment. They won't allow brokers to come up to show the apartment. They won't transfer without the attorney's fees. All of those issues are before the Supreme Court where they belong. Post recognized, the Court of Appeals recognized that in residential cases you can still get a Yellowstone notwithstanding the amendment of the statute.
Okay.
So Geary says
I
very
just had this
clearly,
eerie reminder of when I used to be in housing court, so
but we shouldn't have to be in two courts.
Thank you both.
Thank you very much.
I'll watch him.
Oh. Well, that's why I'm putting it in here.